Oh, good morning. Good morning, good morning. Thank you all for being here. My name is Ben Trachtenberg, and I'm the Associate Dean for Academic Affairs here at the MU School of Law. Professor Drake, Professor Rives, I appreciate the opportunity to be with you this morning at this fantastic symposium. To everyone joining us, whether you're one of the 209 people who registered in advance to attend remotely, or about the 100 or so who registered to be with us in person, or people who don't believe in registration but just showed up. I welcome you all. Let me welcome you on behalf of Dean Larissa Lidsky, who's traveling this week. She asked me to express her regret that she could not be here in person and to thank everyone who put in so much work into making this event happen. I realize that most, if not all of you, are familiar with the work of the Mizzou Law Veterans Clinic, but I cannot resist the opportunity to briefly brag about its work. Each semester, the clinic enrolls students who assist real clients. These clients are military veterans and their families, and the clinic helps them to secure disability-related benefits. Professors Angela Drake and Julia Rives are licensed attorneys who oversee this student work. Since beginning in 2014, the clinic has directly assisted hundreds of veterans clients. By working on real cases, students gain practical experience that supplements their classroom learning. Because the clinic is there, veterans get benefits to which they are entitled, but they otherwise might be denied. So it's a win-win. And if I can say so, it's actually a win-win-win. I say this because in addition to teaching our students and helping its clients, the clinic helps to educate the broader community about veterans law. With its annual symposium, the clinic gathers experts to share their knowledge with practitioners and others interested in the field. Recent topics have included judgment and courage, the role of attorneys in critical military and veterans issues, and Veterans Appeals Improvement and Modernization Act of 2017, finding footing, which, as we'll discover in the not-too-distant future, that footing is still being sought. In addition to providing free CLE credit, which is nothing to sneeze at and presumably has encouraged some attendance from the local bar, this year's symposium continues the clinic's tradition of sharing information about the latest events in veterans law. Our topic is pushing the envelope, first in advocacy for America's heroes. As usual, we have an impressive lineup of speakers, which includes our own professors Drake and Rives, along with honored guests. Today, we will hear from Mel Bostwick, Amy Odom, Professor Amy Kretkowsi, Bart Stichman, Captain David Rogers, Lieutenant General Richard Harding, Captain Janelle Murphy, Joe Neely, and Lieutenant Larissa Tiller. Seeing Captain Murphy and Lieutenant Tiller on the speakers list is especially gratifying because they are both graduates of Mizzou Law who worked in the clinic. So if anyone needed evidence that our clinic students are taking the skills they learned at Mizzou out into the working world, we have living proof with us here today. Our speakers will address veterans advocacy at the highest levels, as well as tough, difficult to navigate terrain of legislation and advancing technology. We'll hear also from JAG officers about legal challenges facing current service members. Before we turn to the 9 a.m. panel, I would like to thank some of the many people who made this event possible. First, our speakers are Mollring and Ambler. Our sponsors, are Harper, Evans, Wade, and Nedemeyer, Angen Woods, Giovello, and the Alberhaskey Law Firm. Thank you all for your generosity. It's important to the law school to offer this symposium at no cost to attendees, and financial support from sponsors is essential to doing that. In addition, clinic staff have worked tirelessly behind the scenes to prepare for today. I'd like to thank Eugene O'Loughlin, Martha Bradley, Nikki Ettinger, Mary Firking, and Mary Austin for all of their hard work. Beyond clinic staff, other law school staff have helped with logistics, including Terry Potter and Daryl Yeager. If I have left anyone out, which I surely have, I apologize. That is the risk one takes when one begins enumerating specific people who are worthy of praise. But I wanted to make sure I mentioned at least some people for their hard work, and just keep in mind that there are others who deserve to be mentioned as well, and I'm sorry for that. Our program today will begin with a panel entitled The Black Hole of VA Adjudication, which concerns the aforementioned Appeals Modernization Act. Then we will hear about the wrong stuff, which I'm told may be found from time to time at the Federal Circuit level. After a break, we'll have lunch and then hear from our keynote speaker, Bart Stichman, or maybe even have lunch and hear from him at the same time about, well, maybe we'll hear from him and then eat. Thank you, Professor. And we'll hear from him about the right stuff. So we're covering all the stuff, right and wrong. The right stuff will be focusing on innovation in veterans advocacy. Then we'll turn to smooth cruising in the clouds, covering the ethical duties of virtual lawyers, a subject, of course, that has gotten more important than ever in the past year or so. And after our final panel, moderated by General Harding, we'll hear closing remarks from Professor Drake. When I first came to Mizzou, this clinic did not exist, and when it came into being, it just seemed like such an obvious extension of the mission of the university and the law school, and indeed, a continuation of the purpose of universities in general, and even of the country. I mean, if you think back even to the days of Pericles, he mentioned that his own ancestors had long ago said that it was important to take care of veterans and their families. And it was one of the basic building blocks of running a civilized society, that the people who fight for a country, particularly those who volunteer, and who volunteer to fight for a country that purports to be a government of the people, for the people, and by the people, well, we, the people who govern, owe a duty to those folks who help make sure that the country can continue to exist. And this clinic gets up and makes sure that the public money that has been promised to veterans and their families is actually delivered to them so that they get the benefits that they have earned. And so every day when the students go in to work at that clinic, and when the faculty members who supervise them and the staff members who assist them, they know that they're helping this country and this university perform a vital duty that is essential to what this country stands for. So I want to thank everyone for being with us here today. Again, I'm honored to welcome you here, and I look forward to the day's presentations, which will now begin without any further delay. Thank you all very much. Welcome.
Hello. Oh, good morning. My name is Emily Bergman, and I am a 3L student here, and I am in the Mizzou Law's Veteran Clinic this semester. I became involved in the Veterans Clinic to gain invaluable practical experience and passionately advocate for veterans. We are pleased to welcome back Amy Kretkowsi and Amy Odom. Both of these women are strong veterans advocates with a wealth of knowledge, experience, and charisma. Amy Kretkowsi obtained her Bachelor of Fine Arts from NYU's Tisch School of the Arts in 1988 and obtained her Juris Doctorate from the University of Iowa College of Law in 2008. Before moving to Iowa to practice law, she spent 18 years as an independent writer and producer for television in New York and Los Angeles. Ms. Kretkowsi began her career in veterans law in 2009 as a judicial law clerk to Honorable Mary J. Sholin on the U.S. Court of Appeals for Veterans Claims. She currently works in her own veterans law practice in Iowa. She also serves as an adjunct professor at the University of Iowa College of Law, where she teaches upper-level courses on veterans benefits law. Since 2011, she successfully represented hundreds of veterans and their survivors in their appeals for VA disability and pension benefits at VA regional offices, the BVA, and the CVAC. Ms. Kretkowsi lives in Iowa City with her husband, Paul, and an emotionally unstable husky mix named Ruckus. Amy Odom graduated from the University of Florida with her Bachelor of Arts and Juris Doctorate in 2003 and 2006, respectively. She previously served as a staff attorney and is the Director of Litigation at the NVLSP. She served as president of the CAVC Bar Association and on the United States Court of Appeals for Veterans Claims Judicial Advisory Committee. She is accredited author of multiple editions of the Veterans Benefits Manual, the holy grail of veterans benefits that we use at Mizzou Veterans Law Clinic. She's trained countless attorneys on veterans benefits advocacy, including our own Professor Angela Drake. Ms. Odom currently serves as the appellate coordinator for veterans law practice at Chisholm, and Kilpatrick, a premier veterans law group. Ms. Odom enjoys spending time with her husband and 2 daughters. This is Ms. Odom's 7th time speaking at our symposium, and we hope to have both her and Ms. Kretkowski back for many years to come. Amy and Amy will be speaking on the black hole of VA adjudication, successes and setbacks following the Appeals Modernization Act. After they speak, we will be taking questions and answers. Thank you.
Thank you. Just wanted to make sure that people can hear us, and I think Amy wanted to make sure that we can see the PowerPoint presentation. So I got a yes here from the director's station, so I'm assuming that you can see the PowerPoint presentation, so I'll just jump right into it. I would really like to start off by sending a great big thank you out to Angela Drake and all of her students who have made this symposium possible. It's a real honor to be here again, and truly a magical experience to be talking with Amy Odom and being able to work with her on this presentation. We've been able to have some very interesting conversations back and forth about this material. We're both having certain feelings about the AMA more than 2 years in, and so I'm happy to be here. And on behalf of Amy and myself, I just want to thank everyone for putting this together. We've got quite a bit of material to cover. I'm going to start off with just giving sort of a broad overview of the AMA, and then hand off to Amy, and she's going to talk about more recent cases that are in the that came out of the Federal Circuit and the Veterans Court dealing with AMA issues. And then she's also going to talk about what's coming down the pipe in terms of cases that are currently before the Veterans Court, including one of my own. And so we'll wrap things up there. So the first slide that we've got here that I'm seeing is a quote from the Andrews case that recently came out, and it's actually quoting NVLSP's Veterans Benefits Manual, which as Emily was saying, it is the Holy Grail. I call it the Bible. Amy, went out and wrote it. I went out and bought it. And if y'all aren't using this, and if you're practicing, you should be using this. This is an incredible, incredible resource.
Full disclosure, I did not write this line, which is absolutely beautiful.
Okay, who wrote this line? Do we know?
This was probably Bart Stichman, the keynote speaker today, or
okay, beautiful.
Rick Spataro of NVLSP.
Okay, well, it is a great line, and it is, was adopted in this decision, and I think has probably been quoted in many other briefs and decisions already. I know that I've already quoted this in 2 briefs since the Andrews case came out. So it's a really it sums it up nicely, as well as the heading here that it is a mad AMA world. Let's go to the next slide. So this slide just sort of shows an overview of the whole decision process under the AMA as of February 19, 2019, which is when this new system went into effect. So I'm going to go into a little bit more detail, but I just wanted to sort of lay out the whole new system here. It starts out with the claim, and that establishes the effective date. The veteran files a claim, and that establishes the effective date. And at that point, the duty to assist is in effect in full force, and it applies up to the point the VA issues a decision. Once VA issues a decision, then the veteran will have 1 year for all appeal options to appeal, to go either to what's in the green column or the red column. If you want to appeal within VA, within VBA, at the agency level, you can ask for higher level review or submit a supplemental claim. I've got the form numbers there. Higher level review, no new evidence. You can submit additional argument. You can have an informal conference. I'll talk about that a little bit more in a moment. Supplemental claim, you can submit evidence, and the duty to assist applies again. If you don't want to deal with the regional offices, anymore, and you want to appeal directly to the board, that's your third appeal option. You can file a notice of disagreement. There's a new form number for that. And there's 3 separate lanes that you can appeal at the board. And you need to be very careful, particularly in light of some new case law, about which lane you're going to appeal when you go up to the board. Let's go to the next slide. Okay, so here are some statutory highlights of the AMA. The first one is really critical. You can preserve your original effective date if you appeal any decision that comes from the RO, the board, or the Veterans Court within 1 year of that decision. I think that was a pretty a substantive response to people being concerned about losing the effective date, the appropriate effective date, by appealing up to the court. If you get a decision from the court, from the Veterans Court, and you can appeal that decision within 1 year. You can file a supplemental claim within 1 year and still preserve your initial effective date. The next highlight is the new and relevant evidence standard, which Amy's going to get into in a little bit. The next highlight, which I think is very important and really critical to pay attention to, is that favorable findings are binding on all the subsequent adjudicators down the line, unless there's clear and convincing evidence that those favorable findings are wrong. I would advise you, getting a decision, to really read those favorable findings very, very carefully. Amy and I spoke about this last night. I actually received a decision that had favorable findings that would establish entitlement to service connection. And I ended up filing a request for higher level review because there was no reason for the denial when the favorable findings listed, there's a current condition, there's an in-service event, there's a medical nexus between the two. And I was like, well, so what's missing? And I filed a higher level review, and I got a decision back on that saying, oh, no, sorry. One of these favorable findings was clear error. And so they turned it around. So be careful about reading the favorable findings. All right, let's go to the next slide. Okay, so I mentioned these new appeal options, which we'll go into in a little bit more detail: higher level review, supplemental claim, notice of disagreement. The deadline for all of them, 1 year from the date of the decision. Missing from this, for those of you who have been around before the AMA, is there's no more statement of the case or supplemental statement of the case, and there's no more requirement for a VA Form 9 to perfect your appeal, to continue to go up to the board. This, I think, is, so far, I think this is actually a good thing, because I think the whole statement of the case and the VA Form 9 confused a lot of veterans. So I think this is actually a pretty good part of the AMA. Let's see the next slide. Okay, so for higher level review, the first option on appealing a denial from the regional office, or appealing a decision that you don't like any aspect of it. If you get a decision that assigns the wrong effective date, or assigns what you think is a low rating, you can appeal that as well as an outright denial of service connection. So higher level review is a de novo review that is based just on the evidence that was in front of the agency at the time that they made that original decision. You can't submit any new evidence. And when they issue that decision after doing the higher level review, they have to indicate if there's any evidence that was not considered. So if the veteran submitted evidence after the date of the decision, they're supposed to identify or say that there was evidence that was not considered because it came in afterwards, and explain how the veteran can get that evidence considered on further review. Which is always, they're always going to say file a supplemental claim if you want this additional evidence submitted. Let's go to the next slide. So higher level review is conducted by the DROs. It's the former decision review officers are currently conducting, for the most part, higher level reviews, and so they're supposed to be more experienced adjudicators who didn't take part in the prior decision. And it's usually from a different regional office, although you can ask for the same regional office if you want to. And VA will generally grant that request. And you can also ask for an informal conference with the decision review officer who's going to ultimately make the decision on the higher level review request. I initially, when this first started, I had a couple of not great experiences with the informal conference, and so I stopped doing them, and then I started up again. And I've since had some better experiences with the higher level review informal conference. And there's I guess it really depends on what you feel is in the record, what you feel the error is that was made in the decision. And if it's something that you can talk with someone about, sometimes it's just better to get someone on the phone and explain to them why you think their decision is wrong. And in a few situations more recently, having this informal conference has been helpful. Let's go to the next slide. Okay, so like I said, I was initially sort of hesitant on the higher level review, but these are situations that I've been using when I sort of want to think, okay, when am I going to choose higher level review? It's pretty easy to figure out when you're going to choose to go the supplemental claim lane, right? Because if you know that there was other evidence that you have now that you want to submit, that you want to get them to consider, that makes sense to choose the supplemental claim lane. Choosing higher level review, it takes it's not that straightforward. I generally want to be able to identify a very clear error. The DROs now, I think, are less empowered, right, than they used to be. They used to be able to do, seems to me, they used to be able to do all sorts of things that they can't do these days on higher level review. Higher level review, it seems to be that they can really only turn things around if there is clear error. And so some of these errors that I've noticed that I've been able to successfully have an informal conference and get them to turn the decision around is assigning the wrong effective date. I see this all the time with TDIU, with total disability rating based on individual unemployability. They will, the regional office generally will assign the effective date as of the date that they receive the TDIU application, which if they receive that application during the pendency of an original claim or during the pendency of a request for an increased rating, that the date of the application is not necessarily the correct date for the assignment of TDIU. The request for TDIU is not a separate claim. It's part of the underlying claim for service connection for an increased rating. It's an attempt to get the appropriate rating. It's not a separate claim. And the regional offices generally, if they see an application, they'll assign the effective date as of the date that they receive the application for TDIU. And that's pretty easy to turn around, I have found, on higher level review. More recently, I had a case where the RO assigned a low rating for a condition, but there was an alternative diagnostic code that I felt should have been considered. And this was one of the cases that, maybe a year ago, I probably would not have done higher level review on, but I rolled the dice and I did higher level review and it paid off because I had an informal conference and the DRO agreed when I pointed out what was in the CMP report, what was, at the time of the decision, what was in the VA exam, what was in the medical record, the evidence that was in there that supported that the assignment of this other alternative diagnostic code, which would get the veteran 100% rating versus the diagnostic code that they assigned a 30% rating. And so that was, it might not work in all situations, but it's just something to think about. Obviously, if they don't consider favorable evidence of record, that you can point out to the decision review officer and get a new decision based on consideration of that new evidence. If they fail to consider an alternative, either expressly raised or reasonably raised theory of entitlement, if they deny on a presumptive basis, but maybe they could have granted on a direct basis, or if they deny on direct and could, or 1151, and they could have granted under secondary. I've seen that quite a bit. If someone has a condition that's the result of treatment for another service-connected primary condition, and filed a claim and said, under 1151, they wanted to get benefits, and they're denied under 1151, but because they were having treatment for a service-connected condition, developed a secondary condition, the RO should have considered entitlement to service connection on a secondary basis. The failure to consider that alternative theory is the sort of error that can be turned around on higher level review. The failure to adjudicate or defer an expressly raised claim. So if your veteran filed a claim for 5 different issues and they only addressed 4 of them, that needs to be pointed out. I think you can point that out at the decision review to the decision review officer. And a very clear misapplication of the law is something that can be turned around on higher level review. All right, let's go to the next slide. Supplemental claims. So here's where we're going to have a little bit of fun on this one. So the supplemental claim is what you'd want to submit if you have new and relevant evidence. So if you got new and relevant, you get a decision, it's a denial. 3 months later, you get a favorable nexus opinion. You'd want to submit a supplemental claim, and if you do so within the year, you can preserve your entitlement to that initial, the original effective date that's resulting in the first denial. It has to be the new and the new evidence has to be relevant. And then the next adjudicator will consider that evidence, and it's not supposed to present a higher evidentiary standard. But I'm going to toss over to Amy to make a few points about this new and relevant, not to be confused with new material, or maybe to be confused with new material. But Amy's going to explain it all to us.
Well, I don't know about explaining it all, because I think that the fun part of this conversation is that we really don't know what relevant means quite yet under the AMA. And it's a pretty, because that's going to tell us whether we can get a claim re-adjudicated and keep that effective date, which is, the highlight of the AMA for veterans and their advocates. So I've taken a look at a few things, and I think that we have 3 possible standards for what relevant means under the AMA. And there's like a high, middle, and low standard. And the high standard comes from this case called Kaiser versus Wilkie, which is not even an AMA case. It was about a different regulation that applies when VA receives official service records. So like service medical records or unit histories or something like that existed at the time of a prior denial, but wasn't associated with the claim at that time and not considered. And that regulation says that VA will reconsider the previously denied claim if the records are relevant. And Kaiser, the Federal Circuit said that relevant in the context means that the records have to reason why the claim was denied. So in that case, a Vietnam veteran filed a claim in the 80s for a nervous condition, is what they called it back then. He went to a VA exam and told the examiner that he had participated in Operation Harvest Moon, which was a combat operation. But the examiner diagnosed him with a personality disorder and said that there was no acquired psychiatric disability related to service. So VA denied the claim the regional office denied the claim based on the lack of a diagnosis. And the Federal Circuit noted time there was evidence in the record that he had participated in combat, his statements to the VA psychiatrist. But those of us who have been doing this for a long time, we know the office, especially in 1983, would never have accepted this veteran statements as evidence of combat, like establishing combat, unless there were service records that corroborated that. Well, guess what? There were service records that corroborated that. And many years later, the veteran submitted them to the VA and said, okay, now reconsider. I have. The circuit said, no, those are not relevant records, because the reason why the claim was previously denied was not because they didn't believe that you were in combat or that you didn't have an in-service psychiatric injury, but because you didn't have a diagnosis. To be relevant, the evidence has to relate to the reason why it was previously denied. That's a pretty high standard, especially when you consider what is the definition of material evidence under the legacy system. Under the legacy system, you could reopen a claim only with new and material evidence. Called Shade versus Shinseki, the Veterans Court said material just means it has to relate to a previously unestablished element, which seems a little different than the reason that the claim was last denied. It doesn't have to be something that was like an act. In fact, that's what VA explained in the Federal Register and the regulatory history for the new and material regulation. It doesn't have to the reason why it was previously denied. It just has to relate to a previously unestablished element. And you have to look at that evidence and make a determination as to whether, based on that evidence and VA's assistance in getting a medical opinion or some other kind of records or evidence as part of the duty to assist, it would substantiate the claim. Amy and I talked about it yesterday. We think that means that Mr. Kaiser would have prevailed if under a new and material standard. Tell me if I'm misspeaking, Amy. Don't need to speak for you.
I think you're right, because under new material, and particularly under Shade, like you said, that it doesn't have to, the new evidence doesn't have to cover every single reason, or even it just needs to relate to, a reason, it just not a reason, an unestablished fact necessary to substantiate the claim. Just it says an unestablished fact, not a reason for the denial. It just says an unestablished fact. And Shade also says that it has to be, that evidence has to be looked at and thinking in terms of, would this evidence help substantiate the claim if we were looking at this in the context of the entire record and considering VA assistance, with VA assistance. So in Mr. Kaiser's case, like you had mentioned last night, if they had that Operation Harvest Moon documentation, then maybe they could have gone and gotten a better, a medical opinion from a doctor showing, hey, he had participation in this combat operation. And so maybe the doctor would not have rejected the credibility of what he was saying, right? And so that's Shade. And so yeah, and I think, where we went back and forth, and I'm still confused, is there a difference between the standards for 3.156A versus 3.156C? But that's for a whole other.
Right. Well, Kaiser makes it seem like it is. Kaiser makes it seem like 3.156C is actually higher than material under 3.156A, the way that the Veterans Court interpreted material. This is because there's a footnote in Kaiser. They dropped a footnote, nothing to do with A, and had nothing to do with new and relevant evidence in his claim. They dropped a footnote saying, this is consistent with this new rule that we have AMA to submit new and relevant evidence to reopen a claim. So that, I mean, you can read that as not really saying much, or you can read that as being very important and signaling Federal Circuit believes is the standard under 3.2501A. So here comes the fun part. So that's, the high strict standard is kind of the reason why I got into what's new and material is because Congress in the legislative history says that relevant in the AMA is supposed to be lower than material in legacy. So we've got that middle ground. Like, it's not as Heiser says it is, and it's lower than material, which is what I intuitively would think is that the term relevant necessarily implies something lower than material. And then you're going to love this. We have the lowest possible standard, which comes from the VA itself, and it's VA adjudication, which is a line. They have a provision that says evidence that confirms a prior favorable finding can still be relevant. So that means if your claim was denied because you had an in-service, there was a favorable finding that you had an in-service knee injury, but you did not have a diagnosis, and you had a diagnosis, but there was no link. So we have two favorable findings. One, current diagnosis, service injury, but unfortunately we don't have any medical evidence making the link. VA's procedure says new evidence confirming the diagnosis is still relevant and is sufficient to reopen the claim. That's low. That's way lower than material. That is very, very low. There's an argument that this is VA's official interpretation of the term relevant in 3.2501. And so my advocacy tip on this point would be that if you are pursuing the regional office, point to the M21 and make the argument that that's the standard and that new evidence confirming a prior favorable finding is still relevant, because the ROs by law are bound by the M21. The board, however, is not. The law has that right. They can say that they disagree with the interpretation as set forth in the M21, and if they have an adequate discussion, an adequate statement of reason or basis for why they disagree, the courts at this point seem to say that that is legally allowable. So if you're at the board and you're still having to fight over whether your evidence is relevant, another advocacy tip I would have is to make the argument that if it's not in a favorable finding by the RO in the prior decision or decision, then it's an issue in dispute, even under the highest standard under Kaiser, because now VA is statutorily required in AMA to list all of its favorable findings. So every resolves in the veteran's favor, it has to list in the decision. That means if it's not listed, then it wasn't really veteran, it's a dispute. So if you can point to those favorable findings and say, look, evidence about is not in these favorable findings and it's an issue in dispute, that should get you over that highest relevant standard.
That's a pretty huge point to make on this, and I swear, the next time you do the symposium, maybe the Supreme Court would have granted cert on the when was the, you said what the petition was filed just last month?
Right. So the petition for cert in Kaiser was filed in September, and for those who are not really nerdy like Amy and I, this would be the second time that Kaiser has gone up to the Supreme Court, which in our world, in veterans law world, is like the Super Bowl because it hardly ever happens, right? It's already been up once about whether VA was entitled to deference, its interpretation of relevance under 3.156C. Ultimately, the Federal Circuit did not accord deference to the VA's interpretation. It sidestepped the issue by saying that relevant is has a plain meaning meaning, so they didn't have to defer to any interpretation. And so now it's going to go back up, hopefully, if the court grants cert on whether that was right, whether that the Federal Circuit's finding that relevant was plain on its face was correct.
So hopefully we'll be able to come back and talk with you about this next year with
I
much
would love
better
that.
news. All right, we can spend forever on the supplemental claim, new and relevant evidence, but let's just move on to the next slide so I can start wrapping up this this top portion. This is another key element, a key feature of the AMA is that you can separate issues. So if a veteran gets a decision on 3 separate issues, the veteran can conceivably request higher level review on one issue, submit a supplemental claim on the second issue, and appeal the third issue to the board with a notice of disagreement. And that's, buyer beware with that one, because then you've got really to keep track of, you got a lot of balls in the air that you're juggling. And so you really need to pay attention and keep track of that. Let's go to the next slide. You can change your review option within 1 year of the initial decision, and you can change it to the supplemental claim after a year if you get an extension for good cause under the regulation, and the supplemental claim is received within the extension period. And so that's at the agency level. Let's go to the next slide. So your options for review after you get a decision on your request for a higher level review, you can't request another higher level review, but you can file a supplemental claim with new and relevant evidence, or you can go directly to the board with a notice of disagreement. After a supplemental claim decision, you've got all 3 options open to you. You can file higher level review, you can request higher level review on the decision on your supplemental claim, or you can submit even more new and relevant evidence with a new supplemental claim. You're still preserving your the earliest possible effective date if you're doing all of this within a year, or you can file a notice of disagreement directly to the board. Let's go to the next slide. Okay, so this slide talks about the different board dockets. And so there's the direct review docket. If you think that there's a clear mistake that was made, it'll go to the veterans law judge, and that law judge will make their decision based just on the record, just on the evidence that was in the record at the time of the prior decision. The goal for the board is 365 days. I think they're not meeting that goal right now, but that is still the goal. If you want to submit new evidence to the board to consider, so say you don't want to do a supplemental claim, but you want to submit new evidence right to the board, you check the evidence review lane, and then you have a certain period of time, I believe it says 90 days, to submit that new evidence. And the veterans law judge will review that evidence in the context of the entire record and make a new decision. If you want a hearing, oh, good luck. You're going to be waiting forever and ever and ever, a really long time. I can't remember. Cheryl Mason said, the chairman of the board said at the NOVA conference that they were, do you recall what it's 2 years to wait for a hearing? It's just a very, very long time that you're going to wait for a hearing. Okay, so let's go to the next slide. So board remands, this slide just talks about the difference between board remands under the legacy system versus under the AMA. And this, I work with a lot of the VSOs here, and this is something that has been confusing to people, because they expect when they get a board remand that if VA is going to continue to deny, they're going to issue an SSOC, a supplemental statement of the case. And that's what happened in the legacy system. That does not happen anymore under the AMA. If the board remands and the regional office is still going to deny, they're just going to issue a new decision. And guess what? You got a year to appeal that decision. And so, and you don't get to, even if you appeal and you select notice of disagreement, you want to go right back to the board, you go to the end of the line. You don't get your same spot on the docket like you used to under legacy. So this is, I'm not entirely keen on this aspect of the way board remands are treated, but this is what the system is now. Let's go to the next slide. So a duty to assist error, when the board remands saying that the regional office made a duty to assist error, and this would be an error that's found, prior to the issuance of that original denial. If they made a duty to assist error, that opens the record. And so once that record's open, you can submit additional evidence as well. And that becomes part of the evidentiary record that has to be considered when the AOJ goes and re-adjudicates the claim. Okay, let's see the next slide. Okay, I emphasize this. This is just that remands don't automatically go back and that the veteran loses his place. This is, this can be confusing to a lot of people, particularly people who were, very familiar with the older system. All right, next slide. Options for review of board and CAVC, Veterans Court decisions. So after you get a board decision, say you get a board denial, you can file a supplemental claim with new and relevant evidence within a year of that decision, and you still get the original effective date, the effective date of that was related to the decision that went up to the board. You can still, within 1 year, if you file a supplemental claim, you can get that effective date. You can also still file a notice of appeal to the Veterans Court within 120 days. After a court decision, this I think is really the true benefit of the AMA, is that you can, if you get a bad court decision, you can file a supplemental claim with new and relevant evidence within 1 year of that court decision and still preserve the earliest possible effective date. Or you can file appeal to the Federal Circuit. And that's all I have on the AMA. So I'm going to, unless there are questions, or we're going to take questions at the end, I'm going to shut up now and toss it over to Amy to tell us about some new and noteworthy cases from the courts.
Okay, great. Thanks, Amy. And we'll see you back for Rettinger, right? Okay. So the first case I'm going to talk about is one that actually came out relatively recently. It's called Military Veterans Advocacy versus the Secretary. This was a petition for direct review of rulemaking up at the Federal Circuit. And a couple of veteran service organizations, a law firm, and an individual veteran that challenged several regulations implementing the AMA. Ultimately, the court found that the organizations and other petitioners only had standing to really challenge 3 of them. The first one was 14.636, which purported to limit when a veteran's representative could charge fees for work on supplemental claims. The second was the regulation that barred filing a supplemental claim while on a claim that was also being litigated up at a federal court. So like the Veterans Court or the Federal Circuit, or when you get to the Super Bowl once in a lifetime, the Supreme Court. And the third one was a regulation that excluded supplemental claims from a process that VA has that you can file a form called an intent to file form and just say, hey, just heads up, I'm going to be filing a claim for benefits within the year. And if you do actually file the designated claim form within a year of that intent to file form, you get the effective date of the intent to file form. Here's the good news. The court struck down the validity of all 3 of those regulations. They were all invalid and inconsistent with the statute, is what the Federal Circuit said. So this means that you can charge a fee on any supplemental claim, or attorneys can charge a fee on any supplemental claim. The problem was that VA had said there are two types, or actually Congress had said there are two types of supplemental claims. There's the type of supplemental claim that you file within a year of the denial, and that's the continuous prosecution supplemental claim. And then there's a supplemental claim that you file more than a year after the denial. That's not continuous prosecution. The difference really is the effective date. You still have to submit new and relevant evidence on both of them. But the difference is if you file within a year, you keep that effective date. If you don't, the effective date is the date you file the supplemental claim. The attorney's fee statute, which previously said that attorneys could only collect a fee after a notice of disagreement had been filed, has now been changed to say attorneys can only collect a fee after an initial decision on the case. And the reason why is that you don't have to file an NOD in every case now. You can submit a supplemental claim. You can request a higher level review. Your only option under legacy to continue pursuing a claim was to file a notice of disagreement. But now under AMA, you have different options. But the VA's regulation said there's a difference between the supplemental claim that you file within a year and the supplemental claim that you file afterwards. And you don't get fees on the one that you file after a year until we have a decision on the supplemental claim. You can get fees if on the one that you file within a year, even if it's a grant and we don't issue a new denial, but you have to have a new denial on a supplemental claim that you file after a year in order to get fees. Court said, no, that doesn't make any sense, and struck it down. The other one, the regulation said you can't file a supplemental claim and go to the Veterans Court or the Federal Circuit at the same time. Again, the Federal Circuit said there's no support for that in the legislation. In fact, it seems inconsistent with the legislation, struck that down as well. And then VA said, because of the effective date statute, we can't let you file an intent to file on a supplemental claim. You have to, for continuous prosecution, you have to file the supplemental claim form, and you only get the effective date that goes to supplemental claim. We can't allow you to file an intent to file and get that effective date. And again, the Federal Circuit said no. There's no reason why the legislation wouldn't allow that, and it's therefore inconsistent with the legislation, and struck it down. So this is the first major case that we've had striking down AMA regulations, and it was a slam dunk for veterans and their advocates. Andrews versus McDonough, not so much a slam dunk for veterans and their advocates. This case addressed a question that was really left entirely open by the AMA, which is what happens when you get a remand from the Veterans Court? Can you submit new evidence? Under legacy, there was no question that you could. Once you got a remand from the Veterans Court found that the board had committed some sort of error and vacated the board's prior decision and remanded the appeal for a new decision. There was no question that you were allowed to submit new evidence that the board had to consider. And that's because at basically virtually every step along the way in the legacy process, the veteran was entitled to submit new evidence that the VA had to consider. And that the Federal Circuit touched on a bit in MVA, the case we just discussed, did account for some of the delays that we saw in the processing times in the legacy system. So in Andrews, the veteran had a board decision on his knee ratings, didn't agree. Well, on the way up to the board in AMA, he selected the direct review docket, which means that he said, I don't have any more evidence to submit. I just want the board to decide my claim. Just go ahead. So the board under the statute then was limited to reviewing only what was before the regional office on the initial decision, right? So the record closed. So he gets a denial from the board, goes up to the Veterans Court, as is the case in the majority of the cases at the Veterans Court. The Secretary's counsel agreed that there was an error and that the board's decision should be vacated and the claim remanded for a new decision. But this is where things went awry, because in legacy, we would always have language in the joint motion for remand that would say, on remand, the veteran is entitled to submit any new evidence and the board must assist him in developing the claim and yada, 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 because that was just the rule. They wouldn't allow the language. The secretary would not allow that language in this case because the secretary said, you are now an AMA, and under AMA, the board is limited to reviewing what was in the record at the time of the initial decision on, the initial claim or the supplemental claim, however it got up to the board. And there's no duty to assist for the board anymore. So we're not including that language. So then, even though all the parties agree that there was an error and the case had to go back, it still went to a panel of the Veterans Court for a decision on whether they should put this language in the JMR at all. And here are some cases in the legacy system that created the basis for the language that we would have in legacy JMRs about submitting new evidence to the board. There's Fletcher and Kucharewski. And the Veterans Court said, those cases don't apply anymore. We're in a new system, just like that quote we saw at the very beginning of the presentation from NVLSP. It's a whole new world now. It's a brand new adjudicatory system, and the legacy, don't expect the legacy rules to apply because they don't necessarily apply to this new system. And one rule that doesn't apply is that you have an automatic right to submit new evidence once you go back to the board from the court. The specific reasoning in Andrews was that the veteran selected the direct review lane on his way up to the board, which means he was not allowed to submit new evidence to the board. And those were the rules that he had to abide by going back as well. So one advocacy tip is there's some who argue that, right, but Andrews is limited to when you choose the direct lane going up and you're not allowed to submit new evidence to the board. But if you choose the evidence lane or even the hearing lane, you get to submit new evidence when it goes back down. So you should always choose the evidence review lane on your notice of disagreement just in case. I personally am not entirely convinced by that argument because if you read the Andrews rationale carefully, I think, in my opinion, what they're saying is the deadlines that apply and the rules that apply under AMA apply even when you go back to the board after the court. And the rules under the AMA before the board say that you can only submit, even if you choose the evidence lane, you can only submit evidence within it's like 60 or 90 days of your notice of disagreement. That will have passed a long time ago by the time you get a decision from the board up to the court and then back down to the board. And if you're stuck with that deadline, that means you still can't submit new evidence. So that means that arguably the only way that you could submit new evidence to the board once you come back from the court is if you've argued that your hearing was inadequate for some reason and the court orders a new hearing. Because if you selected the hearing lane, you get to submit evidence at the hearing and within 60 or 90 days from the date of the hearing. So that would reopen the evidence submission period. But those cases are few and far between. Like that is a very special situation that you have to be able to make that argument and succeed on it. But good news, here is the beauty of the AMA. If you have new evidence that you want to submit that you think is really going to make or break your case, just wait for the board to deny it, file a supplemental claim with your new evidence. There's no reason. In legacy, the claim was over. The case was over. Once you got that board decision, unless you had a reason to go back to court, that was it. You were done. You had to submit a new claim and you were stuck with the effective date of the new claim. AMA, it's not over. It ain't over till it's over. So even if you get a bad board decision and you've got evidence that you think is going to be really the smoking gun here, you just submit it once you get that board decision in the supplemental claim lane. Also, if your remand from the Veterans Court is for the board to remand to the regional office to correct a duty to assist error, like they got an inadequate exam or something, when they send it back to the regional office, you're back in the supplemental claim lane, essentially. So the record opens back up and you can submit whatever evidence you have then too. So is Andrews not ideal? Sure. Is it the end of the world? No, because we have all these options under AMA now, including, and if you have the evidence while you're at court, if all of a sudden you come across the smoking gun evidence while you're at court working out this JMR with the secretary, guess what? Under MVA, you can file a supplemental claim then with your new evidence and start marching your way towards that favorable decision for your veteran sooner than you possibly could under legacy. Another case that just recently came out, this was a case from my firm, Chisholm and Kilpatrick, has to do a lot with the forms regime, as my colleague April would say, is a term that I love, under AMA. Everything is on forms. Like if you don't use VA's preferred form, they will kick you out. If you don't check a box on your higher level review claim or higher level review request form indicating that you're opting in from the legacy system, they will tell you you can't get into AMA because you didn't check a box. I mean, they are serious about these forms. And it's supposed to help veterans to, well, what VA's position would be, this is how we're able to streamline the claims processing system, and our adjudicators don't have to spend so much time digging through the file, trying to figure out exactly what the veteran wants. It's all here in the four corners of the form. And that sounds really good, ideally, but the truth of the matter is it's often, the forms are often used as a sword against veterans as well. And so Hall was a case like that, where in 2015, so this was actually a legacy appeal, but even in legacy in 2015, VA issued regulations requiring that all notices of disagreements be submitted on specific forms. That requirement has now been codified into legislation via the AMA. So in January 2019, like I believe it was the day before AMA went into effect, if I'm not mistaken, the RO issued its initial decision on the veteran's claim in the legacy system and tells him to file an NOD on the legacy appeal specific form. But at the same time, the next day they go live with AMA and they've got a new NOD form that applies to AMA, and they publish it on their website and everything, right? So now there's no more legacy NOD forms because any rating decision issued the day after Mr. Hall's rating decision is all in AMA now. So they don't even have an NOD form for legacy anymore. So okay, so February 2019, the same day that AMA goes into effect, he submits his notice of disagreement on the AMA form because now it's live on the website, right? So he probably just went to the website, pulled it down, submitted it. And so 2 months later, the board says, all right, Mr. Hall, we got your NOD. It's on our docket. You'll get a decision, within X amount of time. There's nothing more you need to do. Just chill out and we'll give you a decision. So then 7 months after that, the board issues a decision dismissing the appeal for lack of jurisdiction, they say, because Mr. Hall, you submitted the wrong form. Your case was an AMA case. I'm sorry, your case was a legacy case. So you should have submitted the legacy NOD form, but you submitted the AMA NOD form. And your case wasn't an AMA case because it was issued a month before AMA went into effect. So sorry, we can't even look at your case. We don't have jurisdiction to look at it. And the Veterans Court said no. The NOD form is a claim processing rule. It's an important claims processing rule because it is really VA's way of making sure that they can get through these claims in an efficient manner without having to have adjudicators dig through files, having to look for, form pieces of paper where the veteran write something that they have to then liberally construe as a notice of disagreement. But it's not a jurisdictional rule. And there's a really important difference, because a claims processing rule means it's something that is important and we can enforce, but we can also waive it. But a jurisdictional rule cannot be waived. That is how the board gets its power to even review a VA decision. In that case, we had also argued that the board had waived the claims processing rule by accepting the AMA NOD. The court did not reach that issue and sent it back to the board to reconsider its reasons for dismissing the appeal, because it found that its determination that it had to dismiss it because of the jurisdictional defect was incorrect. So the reason why this is important for AMA is because, as I touched on before, there are a lot of forms in AMA. Everything in AMA is done on forms. And Hall says that the forms requirement are just claims processing rules. They can be waived, forfeited, and the time period for submitting them can be equitably told, which is another important thing that you cannot get with jurisdictional rules. And in my experience, and Amy, I would assume yours too, the adjudicators, because they've been trained to just look at these forms, they don't look outside the four corners of the forms at all. So it's only what's on the form that's going to dictate what the adjudicator does. And this becomes a problem in AMA, especially in notices of disagreement, where the form says, check direct review if you don't have any additional evidence to submit, right? And I've seen cases where the claimant will check direct review, but attach to the NOD material evidence that they want the board to consider, right? So clearly they either misread that as meaning you don't have evidence more than what's attached to this form, or they didn't understand like what exactly that meant. And they really want you to consider this evidence. And the board will say, nope, can't look at it because you checked a box that said direct. I think Hall is going to be really the first tiny little leak in the dam of cases that says, you can't do that. Like you have to, you can't just put your blinders on because we're in AMA and forms are king. You have to be able to look at the full context of the circumstances to determine what the claimant's intent really was. Now we've got a few on the horizon, two really big ones. I'm just going to quickly talk about Aviles Rivera. This was recently argued. This is a case, again, that has to deal with the board's, the record before the board. And so in that case, we have a Vietnam veteran who is legally presumed to have been exposed to herbicides as a result of his service in Vietnam, and herbicides includes Agent Orange. And he now suffers from hypertension. So he filed a claim in 2013 in the legacy system for hypertension. 3 years later, the National Academy of Sciences, by direction of the Agent Orange Act, says it goes and studies to see whether there is a relationship between or an association between herbicides and hypertension, and says there's limited or suggestive evidence. VA receives that report as required by statute. So they have it in their possession. Then the following year, the board remands the claim for a VA opinion that considers the 2016 report. And in 2017, the examiner says, no, this guy's hypertension is unrelated to herbicide exposure, even considering the NAS's conclusion, which was just that there was limited or suggestive evidence of a relationship. So now it's 2018, and veteran, it says he opts his legacy appeal into AMA. I'm assuming that was actually RAMP, which was like the AMA pilot program. So you could opt into the AMA system before it actually went live through VA's pilot program. But in either case, he gets his legacy appeal into AMA. Now the rules have changed, right? Now there's a limitation on the record on the evidentiary window has closed and the duty to assist does not apply. He's an AMA, doesn't apply to the board. Well, wouldn't you know, later that year, NAS determines that there is now sufficient evidence of an association between hypertension and herbicide exposure. To use that report, they have it in their possession. The following year, the board denies the claim based on the 2017 opinion, makes no mention of the November 2018 NAS report. Here's the problem. In this case, Eusebio, out of the Federal Circuit, they said that documents over which the secretary has control, including the NAS studies here, and are dated prior to the board decision, are constructively before the board. And that includes these NAS updates. The problem with that, Eusebio is a legacy case. It didn't address, what's constructively before the board when the evidentiary window is closed. So the issue in the case was the 2018 update constructively before the board, even though it came in after the evidentiary window closed? There are a couple of approaches that the appellant took. One is that it wasn't really evidence, but information, which is also identified in the statute is what the board must consider. And then there was an argument that Eusebio controls even an AMA. We don't have a decision on that case yet. I don't expect one for a while, but it's one to look for. Amy, what is your prediction here?
Well, I actually, I think we are just about out of time. So,
Oh, no.
but I actually, I watched the oral argument and I thought it was interesting because, of course, I'm drawing similarities between this case and the next case that we're not going to discuss because we're out of time, the Reitinger case. But, the secretary at the oral, in the brief and at the oral argument basically said, no harm, no foul. The veteran can file can file a supplemental claim. And so the VA seems to use the ability to file a supplemental claim as a shield to sort of allow it to not consider evidence that was constructively in the record. And in the Reitinger case, the secretary is using the same sort of argument, saying that I could have filed a supplemental claim. And the Reitinger case had to do with VA not considering, the board not considering 3.156C in an AMA appeal when the veteran checked the direct review docket. And after receiving the notice of disagreement with direct review checked, then the veteran submitted relevant deck logs, relevant service records, and the board, like Amy was saying, put the blinders on, and they really love the ability to close the record. That's a really important aspect of the AMA, and the secretary is really sort of hanging on that and basically protecting the board's ability to close the record over the veteran's ability to get a timely and fair adjudication of his appeal. I think in both cases, Judge Toth at the Aviles Rivera oral argument asked about Andrews and was specifically asking how that applied. And so I'm curious to see how this one comes out because I think they might draw a distinction with and sort of limit Eusebio just to legacy. I'm hoping that they don't, but given the how forceful VA uses 38 USC 7113 to close the record, it'll be interesting to see how this one comes out. We've got, and I guess we're going to make available to you the slides for that show the Reitinger case. And like I said, that was an issue with the operation of 3.156C in a legacy appeal where a veteran checks the direct review box. And that's oral argument is now set for December 8th. Say a prayer for me. And do we have any questions?
We're going to do questions and answers via email, if that's okay to stay on track, because we have such a wonderful program today. I wish you both were here, and we will definitely see you next year. Now it's my pleasure to introduce Gunnar Johansson, one of our students, who will introduce Mel. And Amy, thank you, thank you, thank you. Thank you.
Thank you.
We'll be emailing you questions from the chat and from the audience. Thank you.
Great, thank you.
Good morning. Thank you, Dean Trachtenberg. My name is Gunnar Johansson, and I'm a third-year law student here at Mizzou. I'm also a current student in the Veterans Clinic, and I'm loving it so far. I was really excited to do it when I came to Mizzou Law. Nearly every male member of my family has served, including my little brother, who's about to deploy to Qatar in about 3 weeks. So it was very important to me to give back and to be able to help them someday. But I also want to do this as a pro bono practice, too, when I graduate. So this morning, I have the privilege of introducing Miss Mel Bostwick. Mel is a partner at Orrick, Harrington, and Sutcliffe, and a member of the firm's Supreme Court and appellate practice in Washington, D.C. Her practice focuses on high-stakes appeals with a particular emphasis on patent appeals before the Federal Circuit. She also has the privilege of representing pro bono clients and is particularly passionate about using her Federal Circuit experience to help veterans on their appeals to the Federal Circuit. In the landmark case Procopio v. Wilkie, she successfully argued before the Federal Circuit on behalf of Blue Water Navy veterans. The Mizzou Law Veterans Clinic actually filed an amicus brief in that case and worked with Mel's team to make sure all the arguments were briefed beforehand. I do want to read an excerpt of her oral argument here. It is quite astounding. Here is what Congress in 1991 knew. It knew that there was a growing evidence of an association between exposure to Agent Orange and several diseases. It knew that one of these diseases was non-Hodgkin's lymphoma. And it knew that non-Hodgkin's lymphoma affected Blue Water Navy veterans more than other Vietnam veterans. And I talked with her right before this, and she said it was the quietest the appellate court had been. And it was a long time before they actually interrupted her, which if you have done appellate law, that's quite astounding. After that argument, her team secured a 9-2 ruling that Agent Orange Act unambiguously granted Blue Water veterans a presumption of exposure and service connection based on having served in the Republic of Vietnam, even if they were stationed offshore. So before, you had to have boots on the ground to be service connected to Agent Orange exposure. This affected almost 52,000 veterans nationwide, allowing them compensation for being on the ships that used that recycled water that had been contaminated with Agent Orange. Prior to joining Orrick, Mel was an associate at a boutique litigation firm in DC where she represented clients in trial and appellate litigation and before the FCC. She got her BA at Northwestern and her JD at Harvard. She served as a law clerk to Judge Timothy Dyke of the U.S. Court of Appeals for the Federal Circuit and to Judge Thomas Griffith of the U.S. Court of Appeals for the D.C. Circuit. We thank her for support of veterans nationwide and for being here today, and we're very excited to hear from her. So please give a warm welcome to Mel Bostwick.
Much, Gunnar, for that introduction, and thank you to everyone involved with the clinic for inviting me here to speak today. It's a true honor. I've had the privilege, as Gunnar mentioned, of working with the Mizzou Clinic folks, as well as those at other veterans law clinics around the country for the last 3 years, and I have been consistently impressed by the energy and excellence that all of you bring to this critical work of advocating for our nation's heroes. I'm also just a tiny bit jealous. When I was in law school, Harvard had not yet established its veterans legal clinic, so I didn't get the benefit of that experience as a student. At the same time, I'm not sure I would have pursued the opportunity if it had existed. It wasn't until the year after I graduated law school, when I was clerking on the federal circuit, that I started to understand just how much of a need there is for veterans advocates and how much of a difference a lawyer can make for the millions of people who put their lives and livelihoods on the line for the benefit of our country and who ask only for fair treatment in return. I saw just a sliver of their experience in the appeals that would come before my judge. I will never forget the 2 veterans appeals I worked on in my first month on the court. Both of these men had suffered lasting injuries from their time in war, and both seemed to have been denied the full benefits that they should have gotten under the statutes that Congress had passed. But for reasons that had largely to do with the intricate procedural requirements that apply to VA claims, they hadn't gotten everything they deserved, and the court didn't have the power to give it to them. For a fresh-faced law clerk with a keen sense of justice, this was very discouraging. But on the other hand, throughout my year on the court, I also got to see a more hopeful side of the system. I saw advocates like Ken Carpenter and Bart Stichman arguing before the court, and I saw what a difference that advocacy made in their clients' cases. So I'm delighted to be here to, nope, wrong one. So I'm delighted to be here today to speak with you about how we can follow in their footsteps and work through the appellate courts to advocate for meaningful and lasting change for the veteran community. So to start, why is this such a big problem? Why do we need to get all the way up to the United States Court of Appeals to get things right, when we have some pretty good statutes on the books and a system that is meant to be non-adversarial and pro-veteran? There are some cynical answers to that question. You don't need me to fill them in for you. But I think there are other factors at play too. The VA benefit system has to process hundreds of thousands of claims each year. Those claims often involve finding and analyzing records that may be decades old, reviewing filings by people who may or may not be familiar with the law that applies to their claims, and coordinating medical and factual investigations with a legal analysis. That is a fair amount of work. And it's done in the first instance by people, the frontline adjudicators, who by and large have no formal legal training. We've all seen how the language of statutes and regulations can flummox even Supreme Court justices. This is often complicated stuff, and it's understandable that it creates errors. Of course, most veterans don't have legal training either, and there are not enough VSOs and pro bono attorneys to represent them all at the claim stage, where they are not allowed to secure paid representation, even if they know to seek out help and even if they're successful in finding it. And that's where most claims end. Although 43% of all claims are denied, only 16% of claims are appealed. And a lot of bad rules get entrenched that way. Even on appeal from an initial decision, when paid representation is allowed, less than 15% of veterans have a lawyer assisting them, and about 10% have no representation at all. So you have a big complex system trying to apply complex laws to complex facts, and not enough folks who are trained to help veterans navigate that system and preserve their rights. That's a system that's bound to produce errors, and it does. Just of the cases that make it up to the Court of Appeals for Veterans Claims, there is a finding of agency error more than 90% of the time. It is huge. It is more than any other agency that I've seen. It's also not always easy to fix those errors, at least not without some intentional strategy. So this is an overview of the process for reviewing veterans benefits claims, and this will sound familiar to those of you who saw Amy and Amy's presentation before me. As I said, you start at the regional office level. Whether you're filing an original claim, one of those supplemental claims with new evidence, or a request for higher level review. You get a decision, you can appeal it up to the Board of Veterans Appeals. Here you've now got about 100 experienced attorneys who are serving as the judges and supporting staff members, including staff attorneys. You've also got plenary review. The board can look at the law, they can look at the facts, and they can make judgments about both. And they're the last people who can do that. So you have to get your best facts and your best arguments about those facts out at this level. If you get a bad ruling out of the board, then you can move out of the agency level into the court system. And that's actually only been true for a little over 3 decades. Veterans and their advocates fought for a long time to get judicial review of VA's decision, and it wasn't until 1988 that Congress came through with the Veterans Judicial Review Act. So the first court you get to is the U.S. Court of Appeals for Veterans Claims. They get to review the board's legal rulings. They get to review the board's compliance with all the procedural requirements that govern an agency's decision-making. They get to decide constitutional challenges, and they have a very narrow type of review over factual findings for clear error. But that's a heavily deferential standard. This court cannot fix all errors, which is why that board level is so critical for anything that implicates the facts. That only gets more true as you keep going up the chain. The Federal Circuit is the first Article III court that reviews a veteran's case. It has an even narrower standard of review. They can look at the law, they can look at the procedure, they can look at constitutional questions, at least if the veteran has preserved those arguments in the court below, but they can't review facts or even how the law applies to the facts. Their hands are tied. The Supreme Court, which reviews the Federal Circuit, has the same limitations, and that's if you even get them to look at your case. Somewhere around 3% of all petitions for certiorari to the Supreme Court are granted, so it's quite a long shot. And the takeaway here, I think, is twofold. One, with the limitations at the tribunals that are best equipped to resolve complex legal questions, you can see why so much bad law gets made and why it persists. And two, if you want to challenge one of those entrenched rulings, the best way to do it is by having an advocate who can help the veteran set up that challenge at the agency level, where the scope of review is the most generous and any factual issues can get clarified. But that's not always possible. Sometimes you find yourself diving in on a Federal Circuit appeal, and you've got to take the record as you find it. However you end up there, the first rule is always the same. Know your audience. These are the 19 judges of the Federal Circuit, 12 active, 7 senior. I often use a version of this slide with my patent clients to underscore that the judges, even on this expert patent court, don't necessarily have any expertise in the technology involved in their case. But I think a similar message is important for veterans advocates to appreciate. Of course, these judges, they see all the veterans' appeals that come to their court, they know the law very well, and they study each issue extremely carefully. But most of them have no firsthand experience trying to navigate the VA system, let alone an understanding of what disabled veterans experience. Just 3 of these judges have served in the military, and all of those 3 are on senior status since Judge Wallach went senior earlier this year. He and Judge Mayer and Judge Plager are all hearing and deciding cases, but they don't hear nearly as many as the judges in active service. And with rare exceptions, they don't sit on the en banc court that decides some of the most important veterans cases. Judge Hughes has experience from the other side. Before he became a judge, he ran the DOJ Commercial Litigation Branch, which advocates on behalf of the VA in Federal Circuit appeals. So he also has a deep understanding of the VA system. And as a judge, rather than an advocate, he can take an objective view of that system. So the cardinal rule of appellate lawyering applies with special force here. Don't assume knowledge on the part of your audience. Even if something is self-evident to you, something about the process, something about a veteran's experience, you have to explain it clearly and carefully to the judge and the law clerk who will be reading your brief. So I want to talk about a few different ways you can find yourself before the Federal Circuit and what kinds of things you can accomplish there. The first is not the most common, but it is a great way to preemptively fix a lot of the problems that the VA creates. And that's by challenging the regulations that VA adopts when it adopts them. Like basically every federal agency, sometimes the VA's regulations are not exactly consistent with the statutes that they're supposed to be implementing. And there's a statute that allows you to seek judicial review of those rules when they're promulgated, without waiting for the rule to be enforced against you in an individual case. If you do this, you can solve a lot of problems without making thousands of veterans go through that system we talked about, having an unlawful regulation applied to them, and maybe never even having a chance to challenge that bad decision. One recent example of this is the case that Amy and Amy talked about, Military Veterans Advocacy versus Secretary of Veterans Affairs. As they explained, several veterans organizations challenged those rules at the Federal Circuit. I was delighted to be part of that challenge on behalf of Military Veterans Advocacy. I'm even more delighted that MVA entrusted my associate, Robbie Manass, with arguing the appeal and helping him build his courtroom experience early in his career. And Robbie did great. As you can see, the veterans organizations collectively were able to get 3 of the VA's rules knocked out. Veterans are going to get a fairer adjudication process from the get-go because everyone pursuing claims will benefit from this ruling, without each of them having to challenge an unlawful rule one by one. A few things to keep in mind if you're bringing one of these preemptive or pre-enforcement challenges. First up, make sure you're challenging something that you can challenge under the statute, which is Section 502 here. Congress did not make this one easy for us. The words of the statute say that it applies to an action of the Secretary to which Section 552A1 or 553 of Title V or both refers. And those 2 sections in turn have a bunch of their own requirements. So it's a little confusing. Everyone agrees that a regulation codified in Title 38 of the CFR counts, but the VA makes a lot of rules that aren't codified so formally. A lot of them, in fact, are in the VA's M21 adjudication manual. And last year in the NOVA case, in which a lot of us participated, including as amici, the Federal Circuit overruled its prior precedent and held that the manual provisions are subject to challenge under this statute if they essentially function like regulations, which is they're substantive rules that are generally applicable to parties before the agency. That same NOVA decision also clarified another issue that was the source of longstanding confusion. When do you have to bring your challenge? The statute itself, Section 502, does not set a time limit, and the default rule for civil suits against the government is 6 years. But the Federal Circuit for a long time had a local rule on the books that set a 60-day time limit for Section 502 actions. So you have to bring it within 60 days after VA creates the rule you want to challenge. The en banc court, happily, has now acknowledged that rule was unlawful and that the statutory period of 6 years governs. And that's great, because we might not even learn about a bad rule within 60 days of it being issued, especially if it's adopted in the manual rather than codified in a formal regulation, let alone have time to mount a campaign among veterans advocates to challenge it. That extra time is even more important post-NOVA because while the court giveth, it also taketh. Being an Article III court, the Federal Circuit requires litigants to have Article III standing to bring a claim, and that includes a Section 502 action. The Supreme Court has long had some pretty intense standing jurisprudence, but for quite some time at the Federal Circuit, this requirement was not stringently enforced. And if you were a veterans organization with veteran members, you could bring one of these 502 cases. The NOVA case changed that. You now have to show a more direct link between the rule being challenged and the specific members of your organization or you as an individual. And you have to do it at the outset of your appeal. Typically, you do this by attaching affidavits to your opening brief, showing how particular members are affected. Do I need to talk louder? And this is a jurisdictional requirement. So okay, it's not a claims processing rule, this is jurisdictional. So it's very important to get it right or you'll lose your ability to bring the challenge. And finally, don't lose sight of the fact that your challenge can be broader than just saying that the rule is inconsistent with the statute. The APA standard of review here applies as it does to any other agency, and that includes challenging whether the VA's decision-making process was arbitrary and capricious, for example, whether it complied with the requirements regarding notice and explanation of the agency's reasoning and all of those restrictions. So you want to look and see if those are the kind of arguments you can raise as well. Okay, so let's say you're stuck with a bad rule that did not get fixed through a 502 petition, or you've got a problem that doesn't involve a VA regulation at all. Didn't I say there's that really narrow standard of review? Can you really do much at the Federal Circuit in an individual benefits appeal? Yes, if you're adequately prepared. And that includes knowing that narrow standard of review and how to work with it. Remember, you've got to show the court that the decision below turns on an issue of law, not a question about how the VA resolved the facts, and not a question about whether the VA applied the law correctly to those facts. Did it get the law right in the first place? No matter how carefully you do this, you're going to see the same thing from the VA. This court does not have jurisdiction. It's the first argument in pretty much every response brief that the VA files, so expect it, lay the groundwork in your opening brief, and be prepared to defend it. And remember, if you're dealing with a constitutional issue, the court's scope of review gets a little bit broader. Here, the court can look at how the agency applied the law to the facts. It still can't resolve factual disputes, but what it can do is look at the application of law to fact to make sure that that was consistent with the Constitution. This is an issue in one of the upcoming en banc cases, Taylor, where one of the questions is whether the VA violated the veteran's constitutional right of access to the claim system with the way it enforced the effective date statute that applies to benefits. In this case, nobody's disputing what the statute says, so there's not a disagreement over what the law is. The question is, can it be applied to the facts of this veteran's case consistent with the Constitution? And the court is able to look at that application of law to fact. Now, I've mentioned preservation a couple times. It's key. It's right here in the statute. The Federal Circuit can only look at an issue that was part of the CAVC's underlying decision. That means the veteran had to raise it at the CAVC. You can't expect to make a new argument on appeal. And if you're coming into a case new at the Federal Circuit level, you've got to figure out how to work within that restriction. You also have to show that the error you're alleging actually mattered. Even if you're totally right about the law, you're totally right that the VA messed it up, if the veteran would have lost anyway for some other reason, it's harmless error and you're out of luck. Finally, a word about that APA standard, which appears in pretty much the same language in the Federal Circuit's review statute as it does in Title V. So this bottom block here, those are a lot of lawyer words. Don't let them trip you up. Figure out what the heart of your challenge is. And don't just say something's arbitrary and capricious just because it's wrong. A lot of things are unlawful without being arbitrary. You'll waste space in your brief, and you'll burn credibility if you try to make your challenge fit into every one of these boxes. Also, don't underestimate the impact that even an individual appeal can have. We talked about pre-enforcement rule challenges earlier and how it fixes the law for everyone all at once. It's still possible to have that same level of impact even when you're only directly representing one veteran. In addition, of course, to the significant impact you'll have on your individual client's life. An example of this is a case that I worked on with MVLSP a few years back involving the familiar tripartite test for service connection. Tripartite is a word I love to say. I suspect most of you are familiar with this, but to get disability benefits, you have to show the veteran has a disability resulting from personal injury suffered or disease contracted in the line of duty. That middle box is what we call the nexus requirement. The third box is often called the incurrence requirement. But what about that first requirement, a disability? What do you have to show? Well, for a long time, the VA said that you can't just show that you're in pain. Even if that pain is literally disabling you from earning a living or going about your life, they said it has to be pain that's associated with a currently diagnosed disease or injury. That's not what the statute says. It talks about an in-service disease or injury, but the only thing you have to show at present is that you have a disability that's linked to that prior disease or injury. So this is a great success story of an organization here, NVLSP, working hard to look for the right case to bring this challenge up to the Federal Circuit, to make sure that they made all the right arguments at the Court of Appeals for Veterans Claims, and to give the Federal Circuit something that they could use to fix the law. And it worked. And I was very fortunate to be able to work with them to bring this appeal, where the Federal Circuit easily recognized that the VA's approach was at odds with the statute. Disability means functional impairment. Functional impairment includes pain. That decision was a great relief to our client, Ms. Saunders, and it's been cited in more than 13,000 board decisions in just the 3.5 years since it issued. Don't underestimate the impact of individual appeals. That's especially true if you've got an issue where it's Federal Circuit law that you're trying to fix. The Federal Circuit is not immune from making mistakes, and there are a fair number of decisions, many of them older decisions from a time when there weren't as many veterans who had legal representation at the court, that are continuing to cause problems for veterans. An ordinary 3-judge panel can't fix them because they can't overturn precedent. You need the court to sit en banc, which means all of the active judges, those 12 folks on the slide we saw earlier. This is not a common occurrence. Some appellate courts go en banc fairly regularly, but the Federal Circuit hears at most 1 or 2 en banc cases each year. The good news is that lately, they've been using that rare procedure more and more to tackle important issues in veterans law. In the entire time the court has existed, since 1982, there have been 130 en banc decisions. Just 10 of those were in veterans cases. But 5 of those 10 were in the last few years. And in the last few years, only one en banc case was not a veterans case. Why is the en banc court suddenly interested in veterans issues? Obviously, we don't know for sure. I suspect it has something to do with the fact that there aren't a lot of en banc opportunities in the patent space right now, and that's one of the other key areas of the court's jurisdiction. The court has either addressed the problems in patent law en banc, or it's realized it cannot sort them out. But veterans law is a place where they can come to agreement and make some progress, especially in rethinking older decisions. At least in some instances. These are the 5 recent en banc cases I mentioned. 3 of them had unanimity or near unanimity, which can allow the court to make real progress in shaping veterans jurisprudence and providing clarity to veterans and their advocates. One is the Procopio case that Gunnar talked about in his introduction, where I had the honor of arguing before the en banc court and overturning a decade-old panel decision. That panel decision had held that the VA's boots on the ground rule was proper because it found the statute ambiguous in terms of whether service in the Republic of Vietnam encompassed service in the Republic's territorial seas. Because it was ambiguous under Chevron, the Federal Circuit said it had to defer to the agency. The en banc court took that, and in a 9-2 decision, they held no, the statute is unambiguous. A country unquestionably includes the territorial seas that are part of that country, and the VA's rule was invalid. That decision also led to legislative action and to thousands of veterans actually receiving benefits that they had long been denied. I continue to hear from veterans who are suddenly getting their claims granted that they had fought so long. And so it's really great to see just that the real direct impact that a court case, even up at in the obscure appellate area, can have on people's lives. Another one is the Nova case, which I mentioned, where the court significantly and unanimously improved the process for pre-enforcement review challenges. And the third is the Francois case from 2019, where the court used its en banc footnote process to overrule prior precedent. So this is a case goes to an ordinary 3-judge panel. That 3-judge panel decides it, but if there's one issue that they're deciding where they have to overturn prior precedent, they go around to all the judges on the court and get them to sign off on a footnote that says, yep, I agree with that. So there's this just that footnote is an en banc decision. Here they used it to overrule prior precedent regarding the presumption of competency for VA medical examiners. The problem is that the court didn't actually make clear what was changing. They said, there's no presumption of competency, it's now a requirement. And they said, anything we said previously in these couple of cases is overruled to the extent it's inconsistent with what we're saying today. I don't know what that means. We don't get that beneficial clarity that we get from the Procopio and Nova decisions. That same lack of clarity plagued the most recent en banc ruling out of the court in the starkest way possible, an evenly divided court, 6 judges on one side, 6 judges on the other, and that results in upholding the decision below from the Veterans Court. That's the Arellano case. This involved the availability of equitable tolling for the statute governing effective dates for claims. So remember, typically when you file a claim for benefits, your effective date of any benefits that are ultimately granted is the date you filed that claim. But there's also a statute that says if you file your claim within 1 year of discharge from active service, then the benefits are retroactive to the date of discharge from service. Question in the Arellano case is, okay, what if the very disability that you're trying to get benefits for prevents you from filing within that 1 year period? Does the court have the equitable power to say we're going to toll that statute, and even though you didn't file within the 1 year, we're going to give you that earlier effective date as of the discharge from service? Currently, the answer is no, because the Veterans Court said it was no, and the Federal Circuit could not come to agreement. There is a cert petition pending in the Supreme Court. I filed an amicus brief in that one as well on behalf of MVA, and we're waiting for the government to respond. So hopefully the Supreme Court will take that one up and give us some clarity on equitable tolling. We're also waiting to see what the Federal Circuit does in Taylor, where the en banc briefing is underway. This case also implicates the equitable tolling issue, but the Federal Circuit said, yeah, no, we couldn't figure that out, so don't talk to us about that anymore. Instead, they'll be addressing the related doctrine of equitable estoppel. This also applies to that 1 year effective date statute. Here, the veteran, Mr. Taylor, was subjected to toxic chemical exposure by the military as part of the Edgewood Arsenal human experiments. He was forced to sign a secrecy oath that he could not disclose that he had participated in those experiments, and that included preventing him from filing a claim with the VA to get benefits for the disabilities that resulted from the horrific things he endured. So the court will be determining, is the VA equitably stopped from saying, well, you didn't file within the 1 year. Obviously, he couldn't file within the 1 year. He couldn't file until he couldn't file until about 35 years later, when the DoD finally said, okay, we're cutting back on your secrecy oath just enough to let you file a claim. Is the government stopped from denying him full retroactive benefits? A panel of the Federal Circuit had said yes, Mr. Taylor, you get 35 years of back benefits. A few weeks later, the en banc court, out of nowhere, sua sponte, said, nope, we want to rethink this. Now, they issued an en banc order that gives some optimism that they're trying to do the right thing. They're going to take up as I said, they said they don't want to hear about equitable tolling anymore, but they're going to take up the equitable estoppel issue. They're also going to look at this constitutional issue that I mentioned earlier, which is, did the government's oath of secrecy requirement interfere with Mr. Taylor's constitutional right of access to the VA benefit system and the courts? So not great, certainly not great for Mr. Taylor that they took that away from him, but I think there is reason to be optimistic about what the ultimate outcome there will be. Of course, if they don't get it right, there is always the Supreme Court. As the statistics I mentioned earlier show, this is a long shot, but the Supreme Court has taken many veterans' cases in the past, and there's every reason to think it will do so again. There are a number of issues that I think are ripe for their review, most obviously the 6-6 Arellano decision, where, as I said, there's the petition filed recently. We have the Kaiser case that Amy and Amy talked about. I'm particularly partial to this issue in a cert petition that my team and I filed over the summer, where we're asking the court to say that a Q claim is available when the VA denies a claim based on a reading of the statute that a court later says is unambiguously wrong. So here, there was the statute had said the same thing all along. Our client filed his claim in the 70s. There was a VA regulation that didn't go as far as the statute. So they denied his claim based on the regulation, but if they had applied the statute, they should have granted it. He loses. Decades later, the Federal Circuit says, oh, no, this regulation is not valid. This statute unambiguously requires X, the regulation says Y, no good. So when a court says what a statute unambiguously means, that's what the statute has always meant. So we think that qualifies to say that the original decision was a clear and unmistakable error of law, and not, as the Federal Circuit held, a mere change in interpretation of the law. We'll see what the Supreme Court does with that. We are also awaiting the government's response in this case. When you're crafting a cert petition like this, there are a number of strategies to keep in mind. I'll touch on a few key points. First, as you can tell from the cover page, you have to have an absurd number of lawyers on your team. No, but this other excerpt is important. The question presented. It's the first thing the law clerk will read when they pick up your petition, and you've got to persuade them that it's worth their time. These are extremely busy folks. It is so much easier to write a cert pool memo that says you should deny this case, when most cases are denied, than it is to recommend a grant. So you have to capture their attention and convince them you're worth it. And to do that, you've got to drill down carefully on what exactly you want the court to decide. The Supreme Court does not care about an error in one case, no matter how unjust. You have to frame the issue to show them that it's an opportunity to provide necessary resolution of an important legal question that will have significant impact. I always write the QP last. I probably go through at least 20 different iterations of it and then edit the heck out of it with the team. It just, the importance cannot be overstated. You also want, in the QP and elsewhere in your petition, to tell the court why they should care. Notwithstanding outward appearances, Supreme Court justices are people too, and they want to understand not just the doctrinal effects of their actions, but the effects on, people. They also want to understand the effects on other areas of the law. So an issue we talk about a lot in veterans cases is the pro-veteran canon, this idea that statutes that benefit veterans have to be interpreted to effectuate Congress's presumed pro-veteran purpose. But you've got to be careful when you're talking about something like a canon of statutory interpretation, because the Supreme Court's going to be thinking about all of the other canons that are out there. What about, the rule of lenity in criminal cases? What about others? What is this decision in this case going to do in other areas of law that I maybe am not even anticipating? So you have to be prepared to answer that question, and you have to have that in mind from the outset. Another analogy you can draw in the veterans context is to the inter-circuit split. So among Supreme Court practitioners, this is known as basically the #1 way to get cert granted. The Eighth Circuit says this law means one thing, the First Circuit says it means the opposite. We've got to have the Supreme Court resolve it. That doesn't happen in veterans cases because the Federal Circuit, one court, has exclusive jurisdiction over those appeals. It decides all the issues in the area. But you can still show internal dissension that can help prod the Supreme Court to intervene. Obviously, the 6-6 en banc split in Ariano is one way to do that. But even if you've got one or two dissenters, and especially if they've taken the time to pen a dissenting opinion, you can capitalize on that to justify your request for cert. How else do you justify your case for cert? By showing that everybody cares about your issue. Having support in the form of an amicus curiae briefs is crucial. It shows the court that it's not just you, the petitioner, who's saying that this issue is important. It's all these other stakeholders who will be affected by the decision. Amicus briefs aren't just important at the cert stage, though. You only get limited space in your brief to address all of the complicated issues in a case. And sometimes there are side issues that are interesting and helpful, but not important enough to give full attention to in your main brief. So you can use your amici there to help inform the court about all aspects of the issue that's before them, the history, the policy, the human and economic impacts. And when all the big veterans groups sign on as amici, the court notices. These are the amici from one of the recent veterans cases where the Supreme Court granted cert. And it's not just at the Supreme Court. The en banc victory in Procopio, we could not have done that without the overwhelming amicus support we got from veterans groups across the country, including the law school clinics led by Professor Drake. That was a complicated case. It covered a lot of topics. I had to learn about the law of the sea. There was some really intricate legislative history. There were, in fact, issues about other canons of statutory interpretation and how the decision in that case might affect them. There was so much stuff, and we got 14,000 words to address it. So we worked carefully with our amici to ensure that the Federal Circuit got as much information as possible on every angle, and it mattered. It mattered to the decision. It is incredible to me to see this collection of briefs and this collection of advocates, and to see everyone here today or here virtually. I could not have imagined this back when I was a law student, law clerk. And I'm so delighted to be a part of this movement to fight for those who have fought for all of us. Thank you. Should we take questions?
Yes, thank you, Mel. We're going to take questions, and we're going to ask people to come to the mic, and you can form a queue. So if you could stand, sir, please, and ask your question. Thank you.
I don't really know what an en banc is. I was wondering like what that is and why do they like why does the Federal Circuit Court only take some cases en banc?
Because it's a lot of work. So normally when you file an appeal, your case gets assigned to a random panel of 3 of the judges on the court. But there's 19 judges total on the court, 12 of them active. And so, so you get 3 of those judges, they can decide your case. What happens is, if the court has an earlier decision that is precedential, it binds that panel. And so even if that 3-judge panel thinks, you know what, we don't agree with that earlier decision, we think they got the law wrong, they can't say that. They don't have the power to do it. What they have to do is get the en banc court, the full court together, to rehear the case, because only that full 12-judge court has the authority to overturn a prior decision. So basically, if there's bad law that's been made at the panel stage, the only way to change it is getting the court to go en banc. And the reason that it's rare is there's a few reasons, not just that it's a lot of work. One is there's the idea of stare decisis. There's an idea in our legal system that we want predictability, we want continuity, we don't want the law to continuously be changing. It's really hard for people to figure out how to navigate that system if there's no predictability. And so you don't want it to be always the case that a court is saying, no, we got to fix that, no, we disagree. You especially don't want that to happen as a function of the membership of the court changing, because that just undermines sort of faith in our legal system. But it is an extraordinary amount of work. There's a new round of briefing typically in these cases. As you can see from the Procopio slide, there's often a lot of amicus briefing. It's a lot for the judges to read. It's often some of the most complicated issues in the law that they're dealing with, and so it just adds on to an already pretty extreme workload.
The Supreme Court work better if it was the same way?
I got a lot of ideas about how the Supreme Court could work better, but the interesting thing about the Supreme Court is every one of their decisions is en banc, right? You don't have a panel system, so it's sort of like the ultimate en banc court in that way.
Yeah. But would it work better if they had panels?
No, I don't think so. I think with the Supreme Court, with the number of cases that they take being so few, it's really important that we get all 9 of their attention on each of those cases.
All right, thank you.
Thank you.
Hello.
Hi.
I'm wondering how it sounds like most of the work on the veterans law side is dealing with the regulations, not so much the statutory change. I'm wondering how quickly and how chaotically regulations are made and changed and added, so what kind of a timeline are we looking at for that kind of a thing?
Yeah, so it varies, but it's definitely more flexible than the statutory system, right? It is, particularly at this moment in time, really hard to get legislation passed through Congress. It's easier to get it passed through the agency, and the agency can kind of go into more detail on particular issues, right? The statutes tend to be pretty high level, and then the regulations kind of fill in the gaps. It's not a super quick process because under the APA, the agency has to, if it wants to adopt one of these rules, it has to give people notice, it has to take comment, it has to consider them, and then it has to write an explanation of why it's coming to the decision it is. It has to publish that in the Federal Register. There are ways to kind of fast track that process, but I would say typically, getting regulations done is something that could be done on the order of a year, which doesn't sound very fast. They can do it faster if they have to. Often there's ways to, for example, if there's a new statute, there's often kind of an interim rule that gets put in place while they figure out what the permanent rule is going to be. So it varies, but definitely faster and easier than legislation.
So a pretty ever-changing landscape then it sounds like that you're working with.
Yeah.
Thank you.
Thanks.
Good morning. Thank
Good
you for
morning.
coming in. Obviously, Taylor and Ariano are very exciting for veterans law. Do you see any other cases pending or rolling down the chute soon that you're fingers crossed on, or have good opportunities for us?
At the federal circuit level?
Yes, ma'am.
Yeah. Well, I was paying close attention to Amy and Amy's presentation, looking at those decisions that are bubbling up through the CAVC. I guess the Hall case will not be an opportunity because the court got it right, so that's fantastic. I think, there none that stand out in a way that I think, oh, this is going to be an en banc. At least not where the briefing isn't already done. But the thing to do if you want to get involved, if you want to, to work on an amicus brief, is to watch, just watch the court, watch what it's doing. The opinions that they issue come out every day at 11 Eastern, 10 Central. And that will include en banc orders, like in the Taylor case. And as soon as one of those comes out, people are going to be scrambling to do amicus briefs. But also just staying in touch and being in a clinic, great way, because your clinic instructors are certainly going to know about these opportunities. Kind of tracking what the big veterans advocacy groups are doing, what issues they're focused on. So just kind of being aware of what's going on in the space is kind of the most reliable way.
Yeah, I know Professor Drake and Professor Rives pay very close attention to what's happening.
And if
Thank
they
you.
happen to miss one, I'll send them an email right quick asking for
Great.
an amicus brief. So,
Thank you.
yeah.
Hello.
Hi.
What is your favorite thing about being an appellate attorney?
I think what I like best is that my job is basically to tell my client's story, right? I'm a storyteller. And I get, unlike trial litigation where you're sort of constantly dealing with deadlines and having to juggle all manner of things, I get to really focus, really pay attention to the brief that I'm writing, the argument I'm preparing, and think about how best to get this court to understand why my client is so right? And how this case came to be and what effects it has. It's a lot of fun. It's you can make a difference. You can make progress in the law, and that's great. But the day-to-day work itself is also just so much fun.
Thank you.
Thanks.
All right, thank you.
Great.
Thanks, Mel. We really appreciate Mel traveling here from DC and sharing her words of wisdom with us. Just a few quick announcements. At 11 o'clock, our keynote, Bart Stichman, will present. Lunch will be after Bart's presentation. If anybody has questions that were not answered, please feel free to email them to me, including from the first presentation. My email is drakea@missouri.edu. The program material, the PowerPoints, the cases that Mel has been involved with are all on our website. So you can look there for the program material, and we ask that everybody fill out their CLE evaluation form so that we can comply with the Missouri Bar. So thank you, and we'll see you at 11 o'clock for Bart Stichman.
Hello. Oh, that's really loud. Hello, my name is Kara Luchtefeld, and I am a second-year student here at Mizzou Law, and I have had the opportunity to work in the Veterans Clinic this semester, which has been a great opportunity, and my family members have served before, so it's been awesome to be able to help veterans like my family members. I have the pleasure today to introduce our keynote speaker, Mr. Bart Stichman. Mr. Stichman went to New York University, where he received his JD, and then he went to Georgetown University, where he received his LLM. And ever since then, he has dedicated his legal services to helping veterans. He's actually raised over $5 billion in retroactive disability, death, and medical benefits for veterans. He also co-founded the National Veterans Legal Services Program, also known as NVLSP, as you probably heard today, and he did that in 1981. He also helped author our lovely Veterans Benefits Manual, and you've probably heard that referred to as the Holy Grail, and it helps any veterans advocate kind of navigate the process, and at the Veterans Clinic here at Mizzou, we love to use it. He served for 40 years as executive director of NVLSP, and he recently stepped down, but is still serving as special counsel to NVLSP, which just goes to show the dedication he has to helping veterans. And he recently received the National Legal Aid and Defender Association's Charles Dorsey Award, which honors an individual who has provided extraordinary and dedicated leadership to both the equal justice community and to organizations that promote access to justice for low-income people. Please help me in welcoming Mr. Stichman.
Good to see you all. It's a pleasure to be here. I want to thank very much Angela Drake and Julia Rives for their great work and for the Missouri Clinic and all you clinical students for your work on behalf of veterans and their families. We need you all. Access to good counsel is a key, and it has been one of our missions at NVLSP since the outset. The theme here is pushing the envelope, and that's what I've been doing, NVLSP has been doing for its entire existence. But I think it's important to understand why is that important to push the envelope. And I've been involved, as they say, in this area of the law for 45 years. And my observation is that ever since the Vietnam War, the government hasn't kept its promise to veterans. And what I mean by that is it promises veterans or those who serve in the military that if you get hurt or become ill during service, we will take care of you. Your medical costs, the harm to your ability to earn a living in civilian society, all of that, the government will take care of so you're not harmed by your military service. And unfortunately, the government has not kept that promise since the Vietnam War. We did great for those who served in World War II and to a large degree the Korean War. But starting with the Vietnam War, large groups of veterans, that promise has not been kept, I'm sad to say. And the refusal to pay the costs of war, that's a bold statement, occur in two colors. First, I've noticed that the VA and the military departments often don't believe when it comes to claims for benefits what the veteran is stating occurred to them during service, and often their symptomatology after service, their lay statements. And the reason I believe they don't do that is because they know there's a possibility the veteran is lying, and they want to make sure that they're paying taxpayer money to veterans who really deserve the benefits. And the problem with that attitude, besides the fact that it violates the law, which says there's no requirement of corroboration of the veteran's lay statements. You can turn it down if you disbelieve the veteran and you can articulate good reasons why. But the reason why the problem with them rejecting the lay statements out of hand is that you're throwing out the benefit claims of the truth tellers as well as the liars. And so you're not giving the benefit of the doubt to the veterans, and you're not complying with the law that requires you to articulate a reason for the denial. The second aspect of the failure to pay the costs of war have to do with the military and the VA rules and practices that they have that violate the law. There's too many of them. They're wrongful obstacles that veterans must overcome, and that's why we, as you'll hear, use litigation, class actions, and lobbying Congress to get rid of those unfair or illegal obstacles. So, I'm going to take you through a tour of our history and how we have pushed the envelope. And as mentioned, I helped co-found with David Adelstone the National Veterans Legal Services Project and program in 1981. And it's a nonprofit organization based in Washington, D.C. It was created with funds from private foundations and a grant, an annual grant from the Legal Services Corporation, so that we served as a national support center for legal services offices around the nation. We've been pushing the envelope to break the circumscribed rights of veterans based on unfair laws and practices in three major ways. One, through class actions and other law reform litigation, lobbying Congress, and trying to expand the pool of effective advocates. Those are our three major ways that we engage in pushing the envelope. And we started out, even before NVLSP was formed, in focusing on discharge upgrading. And let me get out my watch to make sure I don't go over time here. The Vietnam War, a highly unpopular war, produced a lot of veterans who were issued less than honorable discharges, which prevented them from getting VA benefits, and it was a stigma on them in civilian society, making it a ticket to a lifetime of underemployment. There was a big drug problem in Vietnam. The soldiers, Marines were disillusioned with the war, as was the public, and the military responded by issuing these less than honorable discharges. No other employer in the United States grades your employment when you leave and gives you a certificate saying you're undesirable, as the military did during the Vietnam War, or your service was under other than honorable conditions. And so that's a stigmatizing impact on the veteran. The employers, when they're seeking employment, will ask to see your discharge certificate, and makes it very difficult for the veteran and civilian society. For example, during the Vietnam War, they needed bodies, and they started a program called Project 100,000, in which they lowered entry standards so that people they wouldn't have accepted because they were unqualified before, they let in. And then what happened when they got sent to Vietnam? their performance was unsatisfactory. Surprise, surprise, surprise. And then what did the military do? They discharged them with a less than honorable discharge, making them worse off than when they entered the military. And so David Addlestone started even before he hired me in representing veterans to get discharge upgrades. And I had a background in administrative law, so one of the things we did was file a lawsuit on behalf of a lot of veterans organizations that were advocates, nonprofits like the Urban Law Institute of Antioch College was the lead plaintiff, and the discharge review boards and boards for correction of military records, which are the discharge review agencies with authority to upgrade discharges, didn't write, for the most part, any statements of findings and reasons, didn't explain their decisions. A lot of them were either grant or denied, and that violated the law. It also violated the law that even when they wrote decisions, they didn't make them publicly available so people could see the circumstances in which they'll grant or deny benefits. So we filed this lawsuit under the Freedom of Information Act to get that, and the Administrative Procedure Act, to get those deficiencies corrected, and reached a settlement that required these boards to write decisions that responded to contentions and otherwise explained why they did what they did and make them publicly available. In addition, as you can see, we filed some class actions that resulted in upgrades and discharge for thousands of people who were who were issued a less than honorable discharge, and the court ordered them upgraded. Then, as we're wont to do, we produced a manual in 1980, right before NVLSP was formed, with funding from Legal Services Corporation, to explain to advocates, and there weren't many, and we were trying to recruit them to represent veterans on discharge upgrade applications. We wrote a big manual for them, and some of the organizations. We published a supplement in 1990 of this, but then we've been too busy to produce another supplement, so I'm happy to say that a number of other organizations have banded together and produced a new discharge upgrade manual. So starting in the 80s, we changed our focus more from discharge upgrading to combating unfair practices of the VA. And that was made difficult by two very unfair laws that had existed for a long time. And you've heard Mel talk about the fact that since the Depression, Congress had barred veterans from appealing any benefits denial to a federal court. Veterans were truly second-class citizens. And in addition to that, a law that was enacted in 1862 during the Civil War prevented lawyers from charging over $10 as a fee to represent a veteran on a claim before the VA. That sounds astounding, but actually $10 was a fair price back in 1862 for a lawyer's help in what was then a very simple system. But Congress never changed the $10 limitation due to inflation, and so it became, in effect, an economic bar to lawyers representing veterans, so they were on their own. And so we worked throughout the 1980s, and it was a 10-year battle to get Congress to repeal that law. And we formed an alliance with Vietnam Veterans of America. Vietnam veterans were not treated well at the VA, even more so than veterans from other eras. The VA employees, most of them, a lot of them were veterans from an older generation, World War II or Korean War, and Vietnam veterans were the soldiers and Marines who lost the war. And so there was bad feelings towards them, and their claims didn't get granted as much as they thought they should be. And so they led the battle, and against them were two major forces. One, Sonny Montgomery, the chair of the House Veterans Affairs Committee, who never met a federal court that he liked, and the veteran service organizations, the big veteran service organizations, the American Legion, the Veterans of Foreign Wars, Disabled American Veterans, and they were against it, even though they had millions of members who would benefit from another bite at the apple. All the arguments for repeal were that give veterans the right to appeal after they lose at the Board of Veterans Appeals to a federal court. The worst that can happen is they lose at the federal court. No harm, no foul. Can anybody here guess as to why these major veterans organizations with millions of members who might be benefited from that were against it? This is I know a lot of you, most of you go to law school, so you're probably used to somebody in my position asking you a question. Yes, sir.
I think there was one concern, this might not be the one you're looking for, but that introducing the adversarial court system to the pro-veteran, non-adversarial lower system would muddy the waters.
Yes, that's one of the reasons that the veterans, stated reasons, that the veteran service organizations gave in explaining to Congress why they opposed, that it would change an informal system to a formalized system. It's occurred a little bit since then. But there was another reason that they didn't talk about much. And that other reason was they provided non-lawyers to represent veterans for free at the agency level, and that's still true today. And they were worried that veterans wouldn't need their services anymore, going to lawyers, and it would wipe out their representation system, which was how they gathered members and made them powerful. They didn't really articulate it that way, although the DAV filed a Supreme Court brief against the challenge to the $10 fee limitation, saying exactly that. At any rate, the Senate each year would pass a bill, either 99-1 or 100-0, providing for judicial review either at a U.S. district court, or some bills would put it in the courts of appeals. Every time, Sonny Montgomery would make sure there was never a vote in his committee, at the House Veterans Affairs Committee, on legislation to repeal. We would bring horror cases in hearings that he was finally forced to hold in the mid-'80s, and he would say to us after the hearing, he says, "Why didn't you bring these cases to me? I could get it fixed." And he was right. He could get it fixed. He ran the show like a plantation, and he often was more powerful than the administrator of the VA in getting things done. And he could get it fixed. But what kind of system should we have if it's only on who you know and the ability to persuade that person to get you benefits? That's not a fair system. And so we filed a lawsuit challenging the BVA chairman's signature list. He had a signature list that said, I have to sign off on any board decision in which the claimant, the appellant, the veteran, lives in a district that a member of the House Veterans Affairs Committee oversees. So he's going to make sure that those people are treated well because they're on the House Veterans Affairs Committee, which passes legislation that controls the VA. So it didn't take long for the VA to invalidate, after we filed suit, that challenge, but it showed the unfairness of the system. And finally, in 1988, Congress passed the Veterans Judicial Review Act, which created the U.S. Court of Appeals for Veterans Claims. You've heard a lot about it from the two Amy's and Mel, and they've led an era of reform. Their decisions have, in the last 30 years, forced the VA to follow the rules that have been on the books for all that time. And so the system is much fairer. Before the court came into existence, the Board of Veterans Appeals would have an approval rate of 13%. It would vary each year, 13.1, 13.7, so much so that VA skeptics thought the BVA had a 13% quota system. Now, in the last number of years, approximately 30% of all those who appeal to the board have their claims granted, and another 40% get them remanded, a much better rate of success, and veterans have benefited from the court and its precedent decisions and its impact on veterans below. Then probably our greatest victory in the courts has been this Niemer case that some of you may have heard it about, and it involved Agent Orange. How many people here, I know I can't see the arms and hands of the people who are watching this from afar, but in the room, how many people have heard about Agent Orange? Everybody. Well, one guy here is reading. He didn't raise his hand or whatever. It's a defoliant that was sprayed in Vietnam during the Vietnam War to destroy the foliage so that the enemy couldn't hide. And it had a contaminant in it, TCDD, or dioxin, that was very toxic. And Vietnam veterans started getting ill in the 70s who were served in Vietnam from a number of conditions that weren't explainable. And the VA took the position in unpublished fast letters, they called them, that the only disease connected with exposure to Agent Orange was chloracne, a skin condition. Finally, Vietnam veterans lobbied Congress so that in 1984, they passed a statute requiring the VA to go through a public rulemaking proceeding. And in this public rulemaking proceeding, the VA had to create an advisory committee of scientists to review the scientific evidence and decide what was related to Agent Orange. The next year, they published a regulation that said there's a connection between, and they said a cause and effect connection between exposure to Agent Orange and chloracne, but no other disease. Surprise, surprise, surprise. The same exact position the VA took prior to the rulemaking. Now, we challenged that regulation in U.S. District Court in 1986. That was before the Veterans Judicial Review Act. And you remember I told you there was a bar to judicial review. So how were we able to file a lawsuit in U.S. District Court if there was a bar to court review? And the answer is there was a loophole in the law recognized by 4 circuits that said the bar to judicial review didn't cover challenges to VA regulations. We filed in U.S. District Court in the Northern District of California. The Ninth Circuit recognized that loophole. And so the case stayed there. It was not thrown out due to lack of jurisdiction. And we argued, our main argument was the effect relationship that the VA required stacked the deck illegally because Congress didn't intend that sort of very strict causal connection in deciding what diseases deserve presumptive service-connected status due to exposure. And we showed examples in other rulemakings where the VA had followed a much lower standard of a statistically significant association based on epidemiologic studies. And there are many, many rules in the Code of Federal Regulations that provide presumptive service-connected status, like Cleracne did, based on a statistical association. So you all may be familiar with the rule from the last 10 years that says anybody who served in the military, who no matter how long after service develops Lou Gehrig's disease, ALS, is presumptively entitled to disability benefits for ALS. What was that based on? It was based on epidemiologic studies showing that veterans, all veterans from whatever year that they studied, that cohort, had a much higher rate of Lou Gehrig's disease than similarly situated people who didn't serve in the military. So the VA turned around and promulgated a regulation presumptively service-connecting that standard, that disease. And so we relied on that, on other rulemakings like that, to show the judge that this cause and effect relationship which the VA demanded was inconsistent with the statute requiring the rulemaking. The judge agreed, invalidated the VA regulation, voided 29,000 denials of veterans who had applied for Agent Orange compensation, and required the VA to undergo a new rulemaking proceeding. Now, while VA started creating its replacement regulations, Congress stepped in. We helped lobby Congress to change the system, which they did in the Agent Orange Act of 1991. And what the Congress did was change the rulemaking process by getting rid of the VA's advisory committee, which were handpicked people, some of whom worked for the chemical companies like Monsanto, who manufactured Agent Orange, and replaced it with a requirement that the VA contract with the National Academy of Sciences, who since then have been advising the VA for decades now. Anyway, every 2 years, the NAS would review the science and recommend to the Secretary of the VA what's connected to dioxin, what is related to dioxin. And Congress also adopted our district court ruling on what the standard should be. It said showing a positive association should get you presumptive service-connected status based on epidemiology in large part. And so those were two great parts of the Agent Orange Act of 1991. But there were two bad parts of that act. The bad parts of the act said when the VA, if it ever presumptively service connects a condition, it can't give retroactive benefits. It has to assign an effective date of the regulation of the date it was promulgated. So if in 1998, 7 years after the act, the VA provides presumptive service connection to multiple myeloma, let's say, people who apply for multiple myeloma who were Vietnam veterans cannot get benefits before 98, only after 98, even if they've had multiple myeloma since 88. And the second negative part is it didn't require the VA to notify anybody about its change in regs. So not everybody who previously applied for that disease would know that they can reapply. So how did we in NEMR get the VA to, in effect, override that by requiring them to identify everybody who previously applied and automatically re-adjudicate their claim and get benefits retroactive to the date of the claim that was denied whenever the VA adds a disease to the list. And here's a secret about how we were able to do it. Is this being taped?
Yes.
Can we block it out at this point?
Jordan, where's our director?
No, I'm guessing, no, he says no. He says you can't do it. Well, I did promise to come out here, and I was told that you were taping. And I have this in here in my speech to tell you the secret, so I guess I'm stuck. So here's how we did it. In February '91, the Agent Orange Act was passed. Now, we got Congress to put in the legislation that the VA still has to complete the NEMR replacement rule process. And Congress gave them 6 months to do it. And so the importance of that was if they service-connected some diseases as a result of NEMR, then these veterans whose claims were voided, and if they had one of those diseases, would get retroactive benefits back to 1985 when the regulation was invalidated. So it was how to get retroactive benefits. The problem was their advisory committee, which was supposed to advise them, rebelled. They were livid. I've read the transcript of their first meeting, and they rebelled, saying the VA had treated the whole process as a joke. That NAS, who was given by the Agent Orange Act $1 million a year to review the science, and the VA treated it out of their hip pocket, they said. And then Fred Conway, the head of the VA who was running the process, said, look, my budget was $45,000 a year. I did my best. So they wouldn't participate in the process. Now the VA was between a rock and a hard place. Congress required them to complete the rulemaking process, and these people weren't going to cooperate. So we reached an agreement, a consent decree, with the VA, overwhelmingly helpful. It said, whenever the VA, during the Agent Orange Act of 1991, adds a disease as presumptively service-connected to dioxin, VA is required to go back, find everybody who previously applied for that disease, and then redecide their claim under the new rule, which they'd win as long as they had the disease, right? All they had to prove is that they were in Vietnam, and this gets rid of the nexus requirement. There's no scientific proof necessary. If you applied for the disease and if you had the disease and you served in Vietnam, you'd get retroactive benefits to the date of your claim. Wonderful consent decree. Why did the VA ever sign that consent decree? My only guess is they never thought that they'd ever service connect anything, and so they never have to pay anything. But they were fortunately wrong. And Congress, the VA with NAS's prodding has service-connected 15 different diseases, et cetera. So that's has resulted in $4.6 billion of retroactive benefits to over 100,000 Vietnam veterans and their survivors. It's been something that we're very proud of. And we're also very proud of a manual that you all have talked about earlier today, the Veterans Benefits Manual. When Congress created the Court of Appeals for Veterans Claims, there were very few lawyers who knew anything about veterans law. And so this was one of our ways of trying to increase the pool of effective advocates, to attract attorneys into a complex system so that they'd feel comfortable representing veterans, and also to upgrade, because we did a lot of training for the veteran service organizations who had non-lawyers represent them. The manual was written in a way that would help them as well. And so that's kind of the product, the written product we're most proud of, and we update it every year, and Lexis Law Publishing publishes it every year. A similar effort, a similar way to get more lawyers involved was the Veterans Consortium Pro Bono Program. Shortly after the Veterans Court was created in 1989, a very high percentage of those who appealed to the Veterans Court, over 80% appealed without a representative. The Chief Justice the Chief Judge of the Veterans Court, Frank Nebeker, did something very un-Washington. He told Congress, you've given us too much money. Get out of the court's budget, take some money back, and fund a pro bono program. And Congress ran that through Legal Services Corporation, and we formed an alliance with 3 other veteran service organizations and got that grant to recruit, train, and mentor volunteer attorneys to represent those people appealing to the Veterans Court. Now, I've talked about class actions, and NEMR was one of them. And unfortunately, the Veterans Court received a petition. It's not unfortunate that they received the petition, it's unfortunate what they did with it, from us and Paralyzed Veterans of America to adopt class action rules so you can file a class action with the Veterans Court. And very important, as the NEMR case showed. And the court rejected it, said, we're appellate court, we can't hear class actions. So that was very unfortunate. And so for many years, we couldn't file class actions in the Veterans Court. However, we had filed before the Veterans Judicial Review Act, NEMR, and this case, Giusti Bravo, to benefit veterans. In this case, very sad story. The VA in Puerto Rico, they have statistics of the percentage of people getting certain types of benefits, in this case, service-connected mental disorders, getting them what was their ratings compared to other regional offices. And they found that the San Juan Regional Office rated service-connected veterans for a mental disorder 100%, more than 4 times the amount of all the other regional offices. And so they sent down a SWAT team to figure out what was going on, and they issued a report saying Puerto Ricans rating Puerto Ricans is not working out. That was their language. Now, what does that mean? The adjudicators at the regional offices in San Juan were Puerto Rican, and they were hearing the cases of Puerto Rican veterans. So they thought they were being too liberal, to the tune of 4 times the average. So what they pressured the adjudication officer, the head of the San Juan Regional Office, to do was issue what to Puerto Rican veterans was the famous or notorious Adjudication Memo 82-3, which said, we've been too liberal in giving 100%. To be 100% disabled for a mental condition, you have to be in a nearly vegetative state of mind. Now, if you take that and you look at the Code of Federal Regulations, Part 4, which I'm sure you do when you look at what disability ratings should be assigned, 100% is not defined as being in a vegetative state of mind. It's a little easier to win, total social and industrial inadaptability. And so we filed a class action challenging that, which resulted in a settlement agreement requiring the VA to re-review all those rating reductions. There were over 1,000 of them, and sending them to a different regional office, which wasn't tainted, the Winston-Salem, and over 80% of the veterans got a rating, got reinstated, the 100% rating, retroactive to the rating reduction, over $60 million in retroactive benefits. So you can see how important class actions can be from Giusti Bravo and from the NEMR case. We've practiced a lot in the Veterans Court. We've filed 5,000 appeals since the court opened its doors. And in individual cases, just like Mel talked about, the courts issue precedential decisions that can help veterans. As Mel pointed out, sometimes she can shepherdize one of her victories and find thousands of decisions that cite it, meaning they probably benefited from it. Or it could mean they distinguished it and we're still denying you, but at any rate, it clearly has an effect. And this is one of the cases we're proud of because it deals with veterans of the First Persian Gulf War. And as you may know, Congress stepped in to make it easier for them to get benefits for the Gulf War syndrome, typical symptoms that occurred that were undiagnosed and there was no explanation for them, yet the VA was requiring proof of a connection between the undiagnosed illness and service, which is not what the statute says. And this decision, precedential decision by the Veterans Court, said that. We created in 2007 another pro bono program called Lawyers Serving Warriors, and we have big law firms around the country who take 400 cases a year that we screen, and we mentor them on individual cases before the VA, before the military on combat-related special compensation, for disability retirement, before the boards for correction of military records, upgrades and discharges. And so that program we're very proud of as well. Now here's a class action that we filed in the 2000s that was not barred, but excuse me, it wasn't in the Veterans Court. It was in the Court of Federal Claims, and it shows how the military system has roadblocks that are unfair, just like the VA system. Military disability retirement, or how many people here are aware of the circumstances in which a service member is discharged from the military with disability retirement? Raise your hand. Not all of you. Okay, let me explain that a little bit. If you have a disability that shows up during service that makes you unable to continue to serve, the military puts you through the disability evaluation system, and that system evaluates whether you can continue to serve due to your medical conditions, and if the answer is no, the military is supposed to assign a disability rating for the unfitting conditions based on the VA rating schedule. And if you get a 30% combined disability rating for the unfitting conditions of 30% or more, you're entitled to monthly disability retirement benefits, TRICARE for the rest of the veteran's life, for the rest of the veteran's spouse's life, and for the minor children and commissary privileges. If, however, you get less than 30%, 0, 10, or 20, you're given a lump sum medical separation payment and nothing else. And so in 2008, Congress, a joint session of Congress, held hearings about what the what the physical evaluation boards, the military, was doing in these cases. And they had a commission look at the differences between the VA ratings and the ratings assigned by the military departments for the same disabilities under the same VA schedule for rating disabilities. And they found the military ratings were much different and much lower. They said in the joint committee hearings that the military was lowballing the disability ratings so they didn't have to pay TRICARE and all those other benefits. And they did something about it by creating a new agency, the Physical Disability Board of Review, so people could apply and get an upgrade in retroactive disability retirement benefits. And they also passed a statute saying, remember when we told you that you have to follow the VA rating schedule? We mean it, we mean it, we mean it. And so the military did much better after 2008, but what about people who were discharged before 2008? And that's where this Sabo lawsuit came in. Those who served in Afghanistan and Iraq were diagnosed in service with PTSD. They were discharged through the evaluation system, found unfit, and they were signed less than 30% and given medical separation, thousands of them. When the VA rating schedule, 4.129, says if you have trauma or stress in service that makes you unfit to continue to serve, you should get at least a 50% rating. The military said, we don't have to follow 4.129. It's not a disability rating schedule, it's a convalescent rating or something that didn't count. And there were 4,400 class members in that suit. The military tried to come up with a way to only give them disability retirement for 6 months and then reevaluate them by the Physical Disability Board of Review. We didn't accept it. We reached a settlement where the military had to assign the VA rating. And so almost all of the 2,200 people who opted into the class got a higher rating, and 1,100 of them had been medically separated. So 1,100 of them got permanent disability retirement retroactive to the date of their separation. And so a great victory for them. I'm going to skip this over because my time is running short and you wanted me to give some time for questions. So let me skip over this statute and cover this case Staub. Staub has to do with reimbursement of medical expenses incurred at non-VA facilities. So a veteran who's getting their health care from the VA has a heart attack or an automobile accident and needs to go to an emergency room. The VA facility is too far away and their life is at stake. So they go to a non-VA facility. They get treated, their bill runs up, and Congress has provided a statute which allows them to be reimbursed or requires that they be reimbursed. And the VA had a regulation that said, if you don't have any health insurance, we'll reimburse you for, let's say you ran up a $45,000 bill, we'll pay the hospital $45,000. But, they said, if you have health insurance that covers part of it, let's say it covers 40 out of the 45,000, we're not going to pay the other 5,000 because you have other health insurance. Now here, the veteran helped the VA by getting health insurance, which they might have paid for or their employer paid for, and the VA's would only be on the hook for 5,000, and they're not even willing to pay the 5,000, and the veteran's on the hook for the 5,000. So Congress passed a Fairness Act in 2010 saying that's not what we meant. If the person has other health insurance, you're the secondary payer. And so the VA didn't think that Congress effectively did what they intended to do. So they didn't change the regulation. So they kept denying people with other health insurance. So we filed the Staub lawsuit, which resulted in the court invalidating that regulation, saying you're the secondary payer, you have to pay them. So we felt very good, walked around pretty good, except the VA instituted a moratorium on the 300,000 pending reimbursement claims after the Staub decision and wouldn't decide them until a new rulemaking proceeding was conducted so that they could process the claims. And in the new rulemaking proceeding, the rulemaking resulted in a rule beginning in 2019 that said the following. The statute, by the way, said we're not going to reimburse you for co-payments. The regulation says we're not going to reimburse you for co-payments. And then they added the words deductibles, and then they added the words coinsurance. Now, how many of you have health care benefits? There are only, as you may know, there are only 3 animals when you go to an insurance company. They'll pay the full amount except for a co-payment, which is usually a very small amount of money, the deductibles for a year that you have, and some people have $1,000, $500,000, whatever it is, and the rest of it is coinsurance, where a percentage of it will be paid by the health insurance company, and the rest is on you. So the only payments that the veteran would have to pay were these 3, which the VA said they wouldn't pay. So their rule in 2019 came out the same way as the pre-Staub rule, meaning we're not going to pay any money. So we went back to court, except we were helped by a very important development. The Yale Law School Clinic had filed an appeal to the Federal Circuit from a denial of a class certification motion in a delay case called Monk. It went up to the Federal Circuit, and the government in the Federal Circuit said the court has class action authority. They disagreed with the position of the VA below, and the court, the Federal Circuit, in a very strong opinion, said the Veterans Court has class action authority, and it's going to help ensure fairness, consistency in the VA process, and have access to lawyers who can represent them. A great victory. And so we then went to court challenging the VA reg that I told you about. The court certified the case as a class action, overturned the regulation, and ordered the VA to re-adjudicate 75,000 decisions, claims that it had denied because of deductibles or coinsurance. And unfortunately, the VA has appealed that decision to the Federal Circuit, as well as another decision in a certified class called SCORE. And the VA hates these class actions. Hate. And what they want to, they'll say the only class actions that should be allowed there are those based on delay in VA decision making. But anything dealing with the substantive regulation or policy is off bounds to class actions. That's what they want the Federal Circuit to hold. And there's an argument in our Wolf case on December 7th, and we'll see where that leads us. I'm just about done and ready for questions, but this case Mel already talked about. We got Mel's help on the Saunders case about disabling pain being a compensable disability. Here's another, we brought a delayed class action, Godsey, which was successful, although its scope was more minor than the Monk case. And I'm going to skip this over, but this has to do with Blue Water Vietnam veterans. And the Niemer consent decree, we went back to court for the 4th time to enforce the consent decree. And recently, the district court ordered the VA to redecide 60,000 Navy Blue Water claims that had been denied based on their illegal boots on ground rule. And I'm going to have to skip this over because there's just not enough time for me to talk about all this, but we have lawsuits on the military side of the fence dealing with the Navy and Marine Corps, which really have promulgated policies that prevent people from getting military disability retirement in different ways than they did before. They did before by giving them less than a 30% rating, but they've been forced by Congress to rely only on the VA rating. So they've figured out some other ways that they don't have to give disability retirement, which were challenging in cases like this. We conduct webinars as another training facility, training detail that we employ, and this discusses it's not a COVID-19 picture. Instead, it's a pictorial of our different activities, our different class actions, training, publications, etc. We've just added a burned claims assistance program to represent veterans exposed to burn pits, which seems to be the Agent Orange of this new Iraq, Afghanistan generation. So I'm sorry for going over a little, but I know I'm keeping you from eating. That's terrible.
Yes, so thank you, Bart, for our many, many. We are going to take the 90 people on live stream can't smell the delicious barbecue that is permeating this room. But while Bart is here, I want to make sure that we answer any questions that you have. And for those of you who are live streaming, if you want to type them in the chat, the students are prepared to run your questions down to Bart. He is the godfather of veterans benefits. Is that okay?
I guess.
Yeah. He's. I have such great admiration for Bart, and his work inspires me every day. It's not about me, but it's just such a wonderful thing to have somebody like Bart motivate us in our work for veterans. So that said, let's have some questions and answers.
Sure.
Yes, my name's Steve Skolnick, and I'm a local retired attorney. And I'm really going to make more of a statement, but this is my statement.
Okay.
And please correct me if this protection does exist and I've missed something. Prior to COVID, I would be coming to these trainings, and I think that we do have a real respect for our veterans, and some of the most impressive people that I've met in terms of veterans law have been out of the Veterans Clinic here. But since I have such an esteemed group of people who've really made this their lives work, this is what I'd like to say, and I'm not going to be the one to carry this, and it might never happen, but I'm going to put it out there, is we would get together and we would say, you know, we would really like to help veterans out, but we're retired and we don't carry insurance. And we would love to do pro bono work. So all I'm going to say, and I'm being purposely vague, it would be wonderful if on a policy level, there could be created some appropriate liability protection, and then I think you would get a number of us who would love to help veterans and take on a few cases. But I leave that to you folks, the expert in the field, and anything you could respond to in that regard would be appreciated.
Okay, I will say that for our Lawyers Serving Warriors program and the Veterans Consortium Pro Bono program provide malpractice insurance to lawyers, including retired attorneys, who take cases from those programs. But I think your statement goes further than that. It would be nice that any retired attorney would be covered to do a pro bono case individually on behalf of a veteran. That's an interesting topic, may require legislation or something, but well thought of. Yes?
Hi. I'm Pat Rowe Kerr, and I'm from Jeff City, and I'm the former State of Missouri Veterans Ombudsman. I am not a lawyer. I am a retired court reporter, and obviously I have been taking care of veterans, helping them navigate systems, educating them, providing advocacy since '02. So I have lots of boots on the ground experience, as you referred to it, which I appreciate from your perspective. I would simply like to encourage those listening and those that are here. When you are prospecting or working with your service member or your veteran, please don't ask them if they are a veteran when you're getting started. Many of our older folk, the one that we really need to access, don't consider themselves veterans because they say, I didn't get off the boat, I didn't shoot a gun. or perhaps they were given significant misinformation from the Department of Defense. So we ask folks to put into their intake forms, did you serve in the military? Everybody can answer that. And once that question is answered, you can run wild with helping them get the appropriate services. And that'll actually help you get backwards from many of those guys and gals that have said, hey, I don't get any benefits, when in fact, they don't even open a piece of mail that comes from the VA because they were told the wrong thing. Simple example, I go to Fort Leonard Wood on a really twice a month basis, and the guy said, I'm paid for by DOD and I'm paid for by the VA. We want to get him out at 25% VA rating. Did you hear what I said? 25% VA rating. There isn't one. But that's taking him under the 30, right? And then lastly, I would just tell you that if you're a veteran that you now have determined is truly a veteran, has a rating that could allow them to be medically discharged. Many of them don't feel, and a lot of this is about emotion and feeling, many of them don't feel that a medical discharge is as honorable as an honorable. If they have a medical discharge, we in the world of advocacy who work with nonprofits nationwide, we have a great ability to help them get financial resources that can provide them with additional help while they are trying to navigate and wade through the arduous system. It's for you.
Thank you.
Thank you.
Hi.
You've shown us some landmark decisions and statutes that have happened in the past for veterans' compensation and benefits. If you had the ability to craft any legislation or any statute or regulation you could, if Congress just would listen to you and you alone, what does the future of veterans' benefits look like? Like what is the next game changer statute or decision?
You should have written me 48 hours ago when I had a chance to think about it. The first thing that comes to my mind, there's a number of technical amendments that would be very important to make to this new modernized AMA process that the VA really was very clever in how they solved this. They went to Congress and said, the VA system is terrible. We're not doing well for veterans. There are delays up the gazoo, and veterans aren't being treated fairly by us because of an antiquated system. And we want to make it streamlined. And so it was a great public relations campaign to get things to change. And there were things that needed to be streamlined. They got rid of the need to file many forms that a veteran had to file to get through the system. But while they were doing it, they made it difficult for veterans to submit new evidence. They don't want any new evidence. It made it difficult if not impossible, for veterans to get hearings at regional offices. They used to get hearings all the time at regional offices. Now, the only way to get a hearing at a regional office is between the filing of the claim and the date of decision by the regional office. And so you have to immediately ask for it. You can't ask for it afterwards. You have to file a supplemental claim or appeal. And when they do ask for it, they don't give it to you anyway, because they don't want to do it. So they've saved tremendous amount of time not having regional office hearings, which are important to avoid having to go to the Board of Veterans Appeals. Then you've heard the wait at the Board of Veterans Appeals for hearings. So there are all kinds of tricks of the trade. Let's say no duty to assist at the board. You've heard the two Amy's and Mel talk about that. Now, they had a rationale which was decent. The reason we need no duty to assist at the Board of Veterans Appeals, they said, was because if there's a duty to assist and new evidence was created, we'd have to go get it, and associate it with the claims file so that the board would review it, and then some more evidence would come in and it would delay everything. Now that's a rational reason. But you didn't have to write it that the duty to assist as a whole doesn't apply. It's just that new records after the RO decision didn't need to be put in, but that doesn't mean you have to treat them in a process way terribly. And so I would fix that. So there's a number of problems of which the two Amy's and Mel talked about that would be very helpful to fix. That's my 2-minute answer to your, 2 minutes you gave me to think about it.
Thank you.
In your experience, what has been the main argument against presumptive service connection? Is it a floodgates policy argument, and what's been your response to those?
The main argument against it or for it, presumptive?
Against.
Against it? Well, I'll give you the reasons for it, and then I'll tell you the against it. With the judge, you're supposed to answer the question first. I'm going to do it second with your permission. The beauty of a presumptive condition is you don't have to prove, and it's difficult to prove, a connection by submitting evidence from a medical professional. And that's difficult for veterans to get. And it makes it really into more of a trial, and it's very difficult for veterans to prove. Then the VA gets their own medical opinion, and there's conflicting evidence in the record. It's a mess, often. With presumptives, you don't have to, it gets rid of that evidentiary problem and makes it much easier for a uniform system to be applied. The argument against it is every Tom, Dick, and Harry who fits within the presumption gets benefits when, if you really looked at it, the likelihood that their disease is connected to something that happened in service is de minimis. So while I'm very pro benefits for people exposed to Agent Orange, the rules now, the presumptive rules, are that a veteran, Vietnam veteran, who gets prostate cancer at the age of 91 gets benefits under these presumptive rules for service-connected disability benefits. If he's totally disabled, that's like $36,000 a year tax-free. And if you guessed or did a scientific analysis of the likelihood that 5 decades after the guy served in Vietnam, and maybe he just landed in a plane there for 1 day, are you going to tell me realistically that that person developed prostate cancer as a result, I'm giving you the most extreme example, of a pit stop at an airport in Saigon? So that's the negative aspect. But it's a system of mass justice. You can't, you can't have a trial in each case. It would cost too much for everybody. And so the presumptives make it more easy to administer in a system of mass justice.
Thank you.
I think what happened here is Angela went out to get lunch for herself. And so she's not here to administer this question and answer session. It looks like there's no more questions. So Angela, could you signal me what I should say?
I was coaching.
That's okay. I just made a little joke. Oh, all right. Here we go.
We had yes. Yeah.
Oh,
We had
you have a question?
Yes,
Oh,
we
I
had
thought
a
you
few
were gonna-
questions from the chat. The first one was, does the veteran's poor treatment during discharge process affect the benefits decision?
Could you repeat that slowly?
Yes. Does the veteran's poor treatment during the discharge process affect the benefits decision?
Let me help. So the person on the chat said that he was helping a veteran who had been discharged in 1959 for being homosexual and recently got honorable, which is fantastic. And he was wondering how that impacts the benefits decision.
Well, the upgrade, this is an upgrade to honorable. If it was for, if the person had a general under honorable conditions, it's possible that the VA reg prevented them from getting VA benefits. And I think the VA is in the process of changing those regulations so that the person can get access to VA benefits. And of course, whatever stigma there was for having a general discharge or even lower, and having homosexual acts or whatever in your DD 214 have been changed by this upgrade. So the stigma should be eliminated, and it looks like the VA is changing the rules so you get access to VA benefits.
The other one is from David Wells, who's a veteran service officer here in Missouri, and he made the observation and question about, can we do anything to help our veterans who served in Thailand who were exposed to Agent Orange? And it seems like if Blue Water Navy, you know, we've got the 12 nautical miles now, and those guys in Thailand were working in, you know, very close to the edge of runways and the perimeter and all that. How can we make it easier for them?
Well, I think there are some bills that are unlikely to pass that are trying to address that situation. And we have cases of ours at the Veterans Court where we're trying to get the Veterans Court to make the VA more uniform in how they decide the cases of people who served on the Air Force bases that the manual identifies as those in which Agent Orange was sprayed.
I don't see anybody behind us, and the smell of barbecue is stronger than ever. So we will adjourn for lunch and come back at 12:30 for ethics. Thank you, Bart.
Yeah.
you.